Chapter 4. Pleading. Key exam issues. The history of pleadings goes back to the common law forms of action, which came to require arcane and specific allegations. Reforms sought to get away from these technicalities. First, code pleading was introduced in the mid-19th century to require only that a plaintiff set forth the facts underlying the dispute. Many states adopted that form of pleading, and a number still use it. Second, the Federal Rules of Civil Procedure introduced what has been called notice pleading, which generally has more relaxed requirements than code pleading. Whichever form of pleading applies to an examination question, a range of issues may need to be analyzed. 1. Sufficiency of the complaint. The defendant may attack the sufficiency of the complaint with a motion to dismiss for failure to state a claim in federal court and many state court systems, or a demurrer in a state court using code pleading. A. Elements of the claim. The complaint must contain the elements of the claim being asserted, e.g., negligent infliction of injury or breach of contract. The elements of the claim are defined by the substantive law that the plaintiff is invoking, e.g., tort or contract law. B. Specificity of allegations. In code pleading jurisdictions, the complaint must include facts constituting the cause of action. In federal court, what is required is a short and plain statement of the claim showing that the pleader is entitled to relief. But this generally must include factual matter demonstrating that the plaintiff has alleged the elements of the claim. The well-pleaded allegations of the complaint must be accepted as true for purposes of evaluating such a challenge to its sufficiency. In code pleading, neither mere evidence nor legal conclusions are well pleaded, and they need not be deemed true for purposes of a challenge to the complaint. Federal courts also may treat conclusory allegations as insufficient to state a claim. Certain types of claims, such as fraud claims, usually must be set forth with more specificity. C. Materials to be considered. The court is ordinarily restricted to the well-pleaded allegations of the complaint in assessing its adequacy. But it may consider any materials the plaintiff has attached to the complaint as exhibits. In addition, if the complaint relies upon documents to support the claim, the court may consider them, even though they are not attached to the complaint, if there is no dispute about the authenticity of those materials when submitted in connection to a challenge to the sufficiency of the complaint. The court may also consider matters that are the proper subject of judicial notice because they are well known and not subject to genuine dispute. D. Alternative of motion for more definite statement or special demurrer. A defendant may also seek clarification of the complaint by making a motion for a more definite statement or filing a special demurrer for uncertainty. Generally, these will be denied unless the defendant shows that the pleading is too uncertain for the defendant to be expected to frame an answer. Nonetheless, in some circumstances a defendant may be able to succeed on such a challenge on the ground that the clarification will show that the claim is subject to dismissal. E. Alternative of motion to strike. A defendant may also move to strike extraneous, redundant, or scandalous matter from a complaint. Such motions are rarely granted. However, if the prayer for relief seeks relief that is unavailable as a matter of law, e.g., punitive damages for breach of contract, the defendant may move to strike that portion of the prayer. 2. Adequacy of the answer. A defendant who does not file a demurrer or motion directed to the complaint must file an answer or risk a default judgment. Issues concerning the answer may arise in a number of ways on an examination. A. Default. Failure to file an answer may result in entry of the defendant's default, foreclosing further defense of the action and entitling the plaintiff to seek the default judgment. At that point, it may be critical to prove that the defendant was properly served, see Chapter I. In addition, defendants are often able to get their defaults set aside by showing that they have a valid defense to the action, some excuse for failure to respond in time, and that the plaintiff has not suffered any prejudice due to their delay. B. Admission or denial of plaintiff's allegations. When the defendant files an answer, Any of the plaintiff's allegations that the answer does not deny are deemed admitted. The defendant must admit those allegations he cannot deny, and may deny on grounds that he lacks sufficient information, only if he cannot ascertain the accuracy of the plaintiff's allegations. An unauthorized denial is ineffective and also results in an admission. Denials in an answer in federal court are subject to Rule 11 requirements to have a valid basis after a reasonable investigation. See below. C. Affirmative defenses. The answer may also assert affirmative defenses, which raise legal grounds why the defendant should not be held liable to the plaintiff, even if the plaintiff proves the allegations of the complaint. Unless he includes an affirmative defense in the answer, a defendant may not raise that defense at trial or by pretrial motion, although omitted defenses may be added to the answer by amendment. See below. D. Waivable and unwaivable defenses. Certain defenses, such as objections to personal jurisdiction or venue, see Chapter I, may be waived unless raised at the earliest opportunity, either by pre-answer motion or inclusion in an answer. Other defenses, such as lack of subject matter jurisdiction, see Chapter II, or failure to join a necessary party, see Chapter V, may be asserted by motion filed after the answer, even though not included in the answer. E. Counterclaims and cross-claims. The answer may also raise counterclaims or cross-claims. 1. Counterclaims are claims by the defendant against the plaintiff. They may be compulsory if they arise out of the event or transaction raised in the plaintiff's complaint. Any other counterclaim is permissive. 2. Cross-claims are claims by one defendant against another defendant and are permissive. 3. Subject matter jurisdiction may be a concern for counterclaims and cross-claims in federal court. See Chapter II. 3. May a party amend pleadings? A. Amendment as a matter of right. Until a responsive pleading is filed, if one is required, a party usually may amend his pleading once as a matter of right. B. Amendment by leave of court. Ordinarily, courts will freely allow amendment after the time when it may be made as of right, unless there has been undue delay or prejudice to the opposing party, or the amendment will delay the trial. C. Effective statute of limitations. Amendments to assert new claims may be made after the statute of limitations for filing a new suit on the claim has run. 1. As to original opposing party. If the added claim is asserted against the original opposing party, the amended pleading usually will relate back to the date on which the original pleading was filed, if the added claim arises out of the same transaction or event as the one raised in the original pleading. With relation back, the added claim will be treated as though it had been asserted when the original pleading was filed. 2. As to an additional or alternative party. Usually, it must be shown that this non-party had notice of the action. In addition, courts have become increasingly strict about whether there has actually been a mistake about the party sued in the original complaint. 4. Has a party properly investigated the claims or defenses asserted in the pleadings? Federal Rule 11 and similar state rules require investigation of claims or defenses before they are asserted in court. In connection with these issues, consider the following. A. What certification was made? The person who signs a pleading, usually an attorney, thereby certifies that she made a reasonable investigation under the circumstances, and that 1. The allegations have evidentiary support, or are likely to have such support after an opportunity for discovery and further investigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or a good faith argument for extending or modifying it. And 3. The claims or defenses are not being presented for an improper purpose. B. Was the proper procedure used to challenge the certification? Before moving for sanctions, a party claiming that Federal Rule 11 has been violated must serve a sanctions motion and allow the opposing party 21 days to withdraw the challenged pleading. The motion may be filed in court only after expiration of the 21 days. This is called safe harbor protection against such sanctions motions. C. What sanctions should be imposed? If there has been a violation and the proper procedure was used, the imposition of sanctions is discretionary, and usually sanctions should be limited to those necessary to deter repetition of the offending conduct, rather than being used to punish the wrongdoer or compensate the victim. A. Introduction. 1. In General 612. The plaintiff begins a civil action by filing in a court of appropriate jurisdiction a complaint seeking some sort of judicial relief against specified defendants. The court thereupon issues its process, e.g., summons directing the named defendants to appear. A defendant appears by filing some sort of response, e.g., answer, motion, demurrer, after which other pleadings and motions may be filed until the case is at issue. 2. Objectives 613. The basic purpose of pleadings is to give notice of the general character of the controversy between the parties. Under Code Pleading C Infra 618, used in such states as California, Illinois, and New York, the pleadings are also intended to narrow and formulate the issues involved in the case. The pleading process thus helps to determine the scope of the action during discovery and at the trial, and define the scope of any judgment in the action. 3. Background 614. At common law, the courts relied exclusively on the pleadings to define the issues. The result was that the pleading process was all-important and pleading rules were extremely technical. Mistakes in the pleading process often proved fatal to the pleader's case and prevented a hearing on the merits of the case. However, under modern practice, the pleadings are merely one stage of the issue-defining process. Discovery devices and the pretrial conference infra, chapters Roman 6 and Roman 8, are also available. Consequently, there has been a strong trend toward liberalizing the rules of pleading and streamlining the pleading process. B. History of pleading. 1. Common law pleadings 615. The original common law courts could grant relief only in accordance with certain recognized forms of action, each representing a particular theory of substantive law, e.g., trespass, case, traver, assumpsit, etc., and pleadings had to be drawn in terms of one of these recognized forms. Thus, the plaintiff was forced to fit the out-of-court transaction of which he was complaining into the mold of one of the forms. Amendments to change the form of action were not allowed, so once a plaintiff chose a particular form, he could recover, if at all, only under the substantive theory of law represented by the form. E.g., if the plaintiff chose trespass, but the facts established traver, the plaintiff could not recover. A. Objective. The basic objective of pleading at common law was to narrow the issues as finely as possible, preferably to a single issue, so that the case could be determined by deciding that issue. B. Numerous pleadings 616. For this purpose, distinct pleadings and counterpleadings were employed, e.g., declaration, answer, replication, rejoinder, surrejoinder, etc. Each party was required to either demur challenge sufficiency of the pleading responded to, see infra 735, or counterplead to each pleading by his adversary. The submission of numerous pleadings was time-consuming, and a defendant could often use the pleading rules for purposes of delay. C. Distinguish equity pleading 617. The courts of equity were distinct from common law courts and were governed by different procedures. Relief was available from the equity courts only where there was no right to recover under any of the forms of action recognized in the law courts, i.e., where the remedy at law was inadequate. Therefore, pleaders in equity had to go outside the forms of action to state their claims. The plaintiff recited facts showing that he had a grievance that ought to be remedied. This concept of fact pleading was the basis of Code Pleading below. 2. Code Pleading 618. The New York Code of 1848, known as the Field Code, originated Code Pleading to relax some of the rigidities of common law pleading. This code, or adaptations thereof, was subsequently adopted in most states and is still retained in several today. It incorporates several important departures from common law pleading rules. A. Single form of action 619. Unlike the rigid common law forms, the fundamental requirement of code pleading is that the plaintiff's complaint be in the form of a statement of facts, showing a right to a remedy. This has been described as abolishing the forms of action and providing for one form of action. Fed. R. Civ. P. 2. Cal. Civ. Proc. Code 307. 1. Effect. Under code pleading, the plaintiff no longer has to select and set forth in the pleadings the particular legal theory of his case. He is entitled to recover under any legal theory applicable to the facts pleaded and proved. Example: plaintiff's complaint alleged that defendant published statements that were injurious to plaintiff's reputation, that plaintiff committed a hijacking, and that unnecessarily specified plaintiff as the person involved. The complaint failed to state a cause of action for libel because the published statements were admittedly true, but it was held sufficient to state a claim for invasion of privacy. If any legal theory will sustain recovery on the facts pleaded, the complaint is sufficient. Briscoe v. Reader's Digest. 4 Cal. 3D 529 1971. Example: a federal statute prohibits states from violating a person's constitutional rights. Plaintiff filed a complaint alleging that the manager of defendant's store had an arrangement with the local police under which the police would assist the store in refusing service to African Americans at its lunch counter. The complaint was held sufficient to state a claim for violation of plaintiff's civil rights under federal statutes, since even if the store itself was not governed by the statute, the police were so governed, and the complaint alleged concerted action between defendant through its manager and the police. Addix v. S.H. Kress & Co. 398 U.S. 144 1970. B. Merger of Law and Equity 620. Another major aspect of code pleading is the elimination of separate courts of law and equity, and of the separate procedures in each court. This change has persisted under modern practice, where the same court is vested with jurisdiction to grant both equitable and legal relief. Fed. R. Civ. P. 1. 1. Remedies distinct 621. Note that while the distinctions between legal and equitable procedure have been abolished, the distinctions between legal and equitable remedies remain intact. The nature of the relief available depends upon the circumstances shown, e.g., whether damage has actually resulted. Example: equitable relief is generally said to be available only where the legal remedy damages is shown to be inadequate. This is called the irreparable injury rule. Example: similarly, various defenses are recognized where an equitable remedy is sought, lashes, hardship, unclean hands, etc., but are not recognized in actions at law. Jury Trial 622. Also note that the distinction between legal and equitable remedies is relevant to whether a jury trial is available. While a jury trial is usually available in an action at law, equitable actions are normally tried by the court alone, although the court may impanel a jury for an advisory verdict on disputed questions of fact. See further discussion infra 148 at sec. C. Limited number of pleadings 623. Far fewer pleadings are allowed under code pleading than in the old common law system, since there is no objective to reduce the case to a single issue through a pleading dialogue. 1. Types of pleadings 624. The basic pleadings allowed under existing codes are shown in the chart on the next page. Note that in contrast to the practices in some other code states, California and New York do not permit a reply to matters of affirmative defense in the defendant's answer. Such matter is deemed controverted without the necessity of a response by the plaintiff. Cal. Civ. Proc. Code 431 1EB. D. Fact Pleading 625. A pleading under the codes must set forth the facts constituting the cause of action in ordinary and concise language. Cal. Civ. Proc. Code 425.10, A1. This is interpreted as requiring an allegation of the ultimate facts of the cause of action or defense involved. 1. Ultimate facts 626. Ultimate facts are those facts that describe in adequate detail, but without legal argument, the circumstances that the plaintiff believes entitle him to a remedy. If the allegations are too general, they are deemed conclusions, and if too much detail is given, it is an impermissible pleading of evidence. Example: suppose the plaintiff's complaint makes the following allegations in a negligence action. I. Defendant operated her automobile in violation of Vehicle Code Section 23101 and injured plaintiff. Roman 2. Defendant consumed 1 gallon of wine at the Green Frog Cafe, less than 2 hours before the accident in which plaintiff was injured. Roman 3. Defendant drove her car while intoxicated and on the wrong side of the highway, causing it to strike the car in which plaintiff was riding. Allegation I could be attacked as a conclusion of law. Allegation Roman 2 might be found to contain only evidentiary matter. Allegation Roman 3 is a sufficient statement of ultimate fact. 2. Consequences of improper pleading of facts 627. Failure to allege ultimate facts constituting every essential element of the cause of action or defense involved makes the pleading insufficient and subject to a general demurrer, or, under some codes, a motion to dismiss, which is the equivalent of a general demurrer. See discussion, infra 735 et seq. A. If sufficient ultimate facts are alleged, evidentiary allegations and conclusions of law can be treated as surplusage, but are subject to a motion to strike. See infra 750. B. If the allegations are too vague, i.e., mere conclusions, the complaint is also subject to a special demurrer. See infra 746-747. 3. Criticism. Under the code pleading system, there is considerable difficulty in determining what constitute the requisite ultimate facts as opposed to evidentiary matter or legal conclusions in various situations. As a result, pleaders tend to use stereotyped allegations and form complaints that have previously been held sufficient. 3. Pleading under the Federal Rules 628. The federal rules have further liberalized pleading standards and have eliminated many of the technical requirements under the Field Code. Today, most states have also adopted the federal rules. A. Pleadings permitted 629. The federal rules authorize even fewer pleadings than the code pleading states above. The basic pleadings allowed by Federal Rule 7A are shown in the chart below. 1. Note: the demurrer has been eliminated in federal courts. In its place, the motion to dismiss for failure to state a claim is used. Fed. R. Civ. P. 12b6. B. Notice Pleading 630. The federal rules eliminate the code requirement of pleading facts constituting a cause of action. Instead, the rules simply require a short and plain statement of the claim showing the pleader is entitled to relief. Fed. R. Civ. P. 882. This has been called notice pleading. 1. Rationale. The purpose of pleading under the federal rules is simply to identify the transaction out of which the plaintiff's claim arises, so that the defendant has notice of the claim. Discovery and other pretrial procedures are relied on for full development of the facts. Conley v. Gibson, 355 U.S. 41 1957. Under the federal rules, the distinctions among ultimate facts, evidentiary facts, and conclusions of law above are therefore said to be unimportant. Any claim may be stated in general terms, and stylized precision in identifying the cause of action is not required. However, generality can be taken too far. A pleading must show that the pleader is entitled to relief, and courts may insist that pleadings include sufficient support for the claims included. Bell Atlantic Corp. v. Toombley, 127s, CT, 1955-27. C. Complaint. 1. In general 631. In most jurisdictions, a civil action is commenced by the filing of the plaintiff's complaint. Fed. R. Civ. P. 3. Cal. Civ. Proc. Code 41110 in New York. An action is commenced by service of process, and the complaint can be filed thereafter. 2. Form 632. The essential parts of the complaint are the caption, jurisdictional allegations, body, prayer for relief, and subscription. A. Caption 633. The complaint must set forth I. The name of the court. Roman 2. The number assigned to the action stamped by the clerk when the action is filed. Roman 3. A designation of the pleading, e.g., complaint for damages, and Roman 4. The names of the parties. Fed. R. Civ. P. 10a. Cal. Civ. Proc. Code 42230. 42240. 1. Note. Suing John Doe defendants is permitted in some states if the plaintiff does not know the true names of all the defendants. See, e.g., Cal. Civ. Proc. Code 474. A. Caution: Doe defendants questionable in federal court due to subject matter jurisdiction concerns. Use of Doe defendants may not be allowed in cases based on diversity jurisdiction. See Supra 347. 2. Effective errors 634. Under modern rules, pleadings must be construed so as to do justice. Fed. R. Civ. P. 8e accordingly. The courts will disregard errors in the form or caption of the complaint that do not mislead the other party. A. Name of party wrong or incomplete 635. An error or incompleteness in designating a party in the complaint is generally harmless error. However, if there is also error in the summons, and as a result the intended defendant is not adequately warned that he is being sued, the action may be subject to dismissal for insufficient process. B. Jurisdictional allegations 636. In federal court, the complaint must contain allegations showing the ground or grounds upon which the subject matter jurisdiction of the federal court is invoked. Fed. R. Civ. P. 8a1. Since federal courts are courts of limited jurisdiction, a complaint that fails to set forth the jurisdictional grounds must be dismissed unless the ground can be supplied by amendment. See Infra 952 et sec. Example. If jurisdiction is founded on diversity of citizenship, a sufficient statement might be: plaintiff is a citizen of New York and defendant is a citizen of California. The matter in controversy exceeds, exclusive of interest and costs, the sum of $75,000. 1. Contrast state practice 637. Jurisdictional allegations generally are not required in state court practice, because state courts usually have general jurisdiction. See Body 638. The complaint must also contain a statement of the facts upon which recovery is sought. In code pleading states, this requires a statement of the ultimate facts constituting the cause of action supra 625, while under the federal rules there must be a short and plain statement of the claim showing that the pleader is entitled to relief supra 630. 1. Separate causes of action 639. Each claim or cause of action should be set forth in a separate group of serially numbered paragraphs, and each paragraph should be limited to a statement of a single set of circumstances. Fed. R. Civ. P. 10b. I. Under code pleading practice, this was an essential requirement. A complaint that lumped together several causes of action was subject to demurrer. Roman 2. Under modern law, however, failure to state separate claims separately, e.g., first cause of action, second cause of action, is simply a formal defect and is not even a basis of objection in some states, e.g., California. Roman 3. Under certain circumstances, It may be important for the defendant to know exactly the grounds on which the plaintiff is proceeding, e.g., where several different claims have been lumped together, and the statute of limitations is different on each claim. In such cases, the defendant's remedy is to file a demurrer for uncertainty under Code Pleading Practice Infra 738, or a motion for more definite statement under Federal Practice Infra 779. 2. Direct allegations 640. The allegations in the complaint should be simple, concise, and direct. Fed. R. Civ. P. 8D1. I. Recitals 641. It is improper to allege essential facts only by way of recitals, e.g., an allegation that agent, while acting as defendant's agent, executed a contract with plaintiff. The proper form is, at all times herein, agent was the agent of defendant. On or about, agent made an agreement with plaintiff. Roman 2. Exhibits 642. Essential allegations may appear in an exhibit attached to the complaint if incorporated by reference into the complaint. Fed. R. Civ. P. 10c. Example. Where the essential allegation is that P gave D notice to quit the premises by a certain date. P can attach a copy of the written notice as an exhibit to the complaint and incorporate it by reference therein. The date can then be ascertained from the exhibit. Roman 3. Consequences of Defect 643. Noncompliance with these rules of form is at most the basis for a demurrer or motion objecting to the defect. In modern practice, such defects are usually disregarded. 3. Allegations on information and belief 644. Ordinarily, the plaintiff's allegations should be based on personal knowledge. However, if the plaintiff lacks personal knowledge of some element of his claim, e.g., is relying on hearsay or conjecture, in code pleading states, the plaintiff may still make the allegation on information and belief. Information and belief may be insufficient under the federal rule, however. In federal courts, allegations can be made only after reasonable inquiry and with a belief that the pleading is likely to have evidentiary support. Fed. R. Civ. P. 11. C. Infra 809 et sec. I. Denials 645. Similarly, in code pleading states, a defendant may deny allegations based on lack of information and belief. Cal. Civ. Proc. Code 43130 and under the federal rules, a statement that the defendant is without knowledge or information sufficient to form a belief as to the truth of an averment has the effect of a denial. Fed. R. Civ. P. 8b5. Roman 2. Importance 646. The use of allegations on information and belief is important where a pleading is to be verified by a party where the pleading party includes an affidavit that the pleading is true to the best of the pleader's knowledge. See Infra 666. Since the plaintiff should not swear facts to be true when she has no personal knowledge thereof. Roman 3. Limitation 647. Allegations on information and belief are improper as to matters which the pleader obviously knows or has reason to know, e.g., events that she witnessed, or matters as to which she has constructive knowledge, e.g., matters of public record. In such cases, pleadings on information and belief will be disregarded, leaving the complaint subject to a demurrer or motion to dismiss. 4. Alternative and inconsistent allegations. I. Inconsistent legal theories 648. A plaintiff may properly allege facts based on inconsistent legal theories. Note that Federal Rule 11 may limit this latitude. See Infra 809 et sec. Example. Plaintiff claims damages as the result of surgery performed on him by Dr. Defendant. Plaintiff may plead in one count that the surgery was performed without his informed consent, hence a battery, and alternatively, in a separate count, that the surgery was negligently performed. Plaintiff is entitled to go to trial on both theories, so that if the facts do not sustain one theory, they may sustain the other. Example. Plaintiff claims that defendant fraudulently induced him to execute a contract. Plaintiff may plead one count for damages based on the fraud, and alternatively, in another count, seek rescission of the contract based on the fraud. 1. Limitation election of remedies 649. However, while a plaintiff may go to trial on both theories and have a verdict on each, he will have to elect one theory prior to judgment because he cannot have two remedies, e.g., duplicate damages for the same injury. Savage v. Van Marl, 39 Cal. App. 3D 241 1974. A. Time of election 650. The plaintiff is not required to make this election until after a jury verdict or fact findings by the court and before judgment. Otherwise, the plaintiff would have to guess which version of the facts will be sustained and thereby lose the benefit of alternative pleading. McCormick v. Kopman, 161 NE2D 720 L, 1959. Roman 2. Inconsistent facts 651. A pleader is also permitted to plead inconsistent versions of the facts. Fed. R. Civ. P. 8D3. However, some jurisdictions require that the facts alleged indicate some reason why the plaintiff could not know which version was true, e.g., plaintiff was unconscious at the time of the injury, or injury-causing events occurred outside the pleader's observation. Roman 3. Alternative defendants 652. The plaintiff can also plead one version of the facts against one defendant and another version against another defendant. Again, some jurisdictions require a reason why the plaintiff could not know which version is true. Example: after plaintiff's husband left a tavern operated by defendant 2, he was killed in a head-on collision with a truck driven by defendant 1. In her wrongful death action, plaintiff alleged that the accident was caused by the driving of defendant 1, whom she alleged had crossed the center line. To recover from defendant 1, plaintiff had to prove that her husband was free of contributory negligence. But plaintiff also asserted a claim against defendant 2, alleging that the accident was caused by her husband's intoxication, which resulted from the drinking her husband did at defendant 2's tavern. Under this version, plaintiff's husband would have been guilty of contributory negligence in connection with the crash. McCormick v. Kopman, Supra. 5. Defenses need not be anticipated 653. Ordinarily, the plaintiff is not required in the complaint to anticipate any defense that the defendant may raise. I. Well-pleaded complaint Rule 654. The rule regarding anticipating defenses corresponds to the well-pleaded complaint rule for federal question subject matter jurisdiction Supra 420, which provides that the existence of a federal defense is not considered in deciding whether a plaintiff's claim arises under federal law. Roman 2. Reply to affirmative defense 655. Although it is not automatically required, a court may order a plaintiff to reply to an affirmative defense asserted in an answer. An affirmative defense is a defense relying on new matter that the defendant must prove to avoid the plaintiff's claim. Fed. R. Civ. P. 7a. The Supreme Court has observed that such a reply may be appropriate when a defendant asserts a defense of qualified immunity. Crawford L.V. Britain, 523 U.S. 574 1998. And some courts now require a reply in that situation. See Reyes v. Sazin, 168 F3D 158 5th Sir. 1999 District Court abused its discretion in failing to require plaintiffs to file reply to defendant's answer containing defense of qualified immunity. D. Prayer for relief 656. A complaint must also contain a prayer for relief, i.e., a statement of the relief sought. 1. In default cases 657. If the defendant defaults by failing to defend, the relief granted cannot exceed what is prayed for in the complaint or differ from it in kind, e.g., an injunction when the prayer was only for damages. Rationale: by failing to appear and contest the action, the defendant has, in effect, acquiesced in the entry of judgment against her. but the judgment entered must conform to the consent given. Fed. R. Civ. P. 54C. Cal. Civ. Proc. Code 580. Infra 998 et sec. 2. In contested cases 658. In a contested case, the plaintiff is not limited to the relief prayed for in the complaint. The court may award any relief to which a party is entitled under the pleadings and proof, even if different from or greater than that prayed for in the complaint. Fed. R. Civ. P. 54C. Cal. Civ. Proc. Code 580. I. Limitations 659. In a few states, a plaintiff is not permitted to state the amount of his demand in personal injury or wrongful death actions. Cal. Civ. Proc. Code 42510B rationale. This rule is intended to prevent sensational publicity for large demands. However, the plaintiff must provide a statement of the damages claimed if the defendant demands one. In any event, such a statement must be made before trial. Roman 2. Caution 660. Some decisions hold that where the complaint alleges specific amounts of damages, the allegations may be treated as binding admissions with respect to the amount of damage sustained. Hence, it may be error to award a greater sum, and such a judgment may be reduced accordingly. Brown v. North Ventura Road Co., 216 Cal. App. 2D 227 1963. 1. Trial Tactics 661. Where evidence at trial indicates that the verdict may exceed the damages pleaded, the plaintiff should seek leave of court to amend the damage allegations and prayer upward. This may prevent the problem noted above. Note that pleadings may be amended even after trial. See Infra 992. 3. Other functions of prayer 662. The prayer is ordinarily determinative of the amount in controversy for jurisdictional purposes. See Supra 367 et sec. In state courts, it may also determine the nature of the action legal or equitable on which the right to jury trial depends. E. Subscription 663. The complaint must be signed by the attorney or by the party himself, where he is acting as his own counsel. Fed. R. Civ. P. 11. Cal. Civ. Proc. Code 446. 1. Effect of signature federal practice 664. In federal practice, the signature on a pleading by a party or his attorney constitutes a certification by him that, to the best of his knowledge, information, and belief, formed after reasonable inquiry, the evidentiary contentions have evidentiary support, or are likely to have such support after discovery. The signature also certifies that the claims or defenses are warranted by existing law or a good faith argument for change in existing law, and that the claim or defense is not interposed primarily for any improper purpose, such as harassment, delay, or increasing costs. Fed. R. Civ. P. 11. See Infra 809 et sec. I. State Practice 665. In state practice, subscription sometimes remains a mere formality. Hancock v. Bowman, 49 Cal. 413 1D 2. Verification 666. A verification is an affidavit at the end of a pleading which avers that the pleading is true to the best of affiant's knowledge, information, or belief. The affidavit is made by the party, or by an attorney or other person on her behalf, if the pleader cannot do so, e.g., because she is incapacitated, or if another person with better knowledge of the facts is willing to make the verification for the party. I. Federal Practice 667. In view of the importance attached to an attorney's subscription in federal practice above, verification by a party is the exception rather than the rule in federal courts. Federal Rule 11 expressly provides that pleadings need not be verified, except where specifically required by rule or statute. Example: the federal rules specifically require verification in shareholders' derivative suits. Fed. R. Civ. P. 23:1. Roman 2. State Practice 668. Some code pleading rules provide that any pleading may be verified, and verification is frequently required by statute, as to certain kinds of proceedings, e.g., quiet title actions, unlawful detainer proceedings, divorce suits. 1. Effective verification 669. If a pleading is verified, the responsive pleading must also be verified, e.g., if plaintiff files a verified complaint, defendant's answer must be verified by defendant. Moreover, a defendant cannot use a mere general denial infra 857 in answering a verified complaint. Cal. Civ. Proc. Code 43130D. 2. How to attack lack of verification 670. If a pleading that requires verification is not verified, the pleading is subject to a motion to strike infra 750. 3. Pleading specific claims 671. As noted previously, the body of the complaint must contain allegations showing that the plaintiff has a right to recover. A. In general 672. The elements of any particular cause of action involve both a substantive and a procedural aspect. 1. Substance 673. Substantive law determines whether a specific incident or transaction results in liability to the plaintiff. For example, calling someone a subversive results in liability for defamation only if the substantive law so provides. 2. Procedure 674. The procedural aspect is one of allocation. The plaintiff must allege enough particulars about the incident to constitute a prima facie case. Other particulars may be relevant, but will be considered only if they are injected into the case by the defendant, ordinarily in an affirmative defense. Example: when plaintiff alleges that defendant called him a subversive, does plaintiff also have to allege that the statement is false in order to state a claim for libel? Or must defendant raise the issue by pleading truth as an affirmative defense? The rule varies from state to state. See Brewster v. Boston Herald Traveler, 188 F. Sup. 565 D. Mass. 1960. I. State Pleading 675. The following discussion of pleading requirements in particular causes of action is primarily important for code pleading states, where the general rule is that every essential element of the cause of action sued upon must be pleaded by allegations of ultimate fact. See Supra 626. Roman 2. Federal Pleading 676. This is not to imply that the elements of a cause of action may be disregarded in notice pleading jurisdictions. Federal Rule 8A requires that the complaint show that the plaintiff has a right to relief, and Federal Rule 12B authorizes a motion to dismiss for failure to state a claim upon which relief can be granted. See Infra 756. However, under the federal rules, 1. Less detail and specificity are required, and 2. Omission of allegations is never fatal, i.e., they can be supplied by amendment. B. Trespass to land elements 677. The essential elements in a trespass action are as follows. 1. The plaintiff's possession or right to possession of the described property, as owner or otherwise at the time of the defendant's wrongful act. In most code pleading states, an allegation of ownership is sufficient to establish least constructive possession, as long as there is nothing in the complaint to indicate that anyone else was in actual possession. 2. The defendant's wrongful intrusion on the described property. 3. Damage proximately caused by the defendant's intrusion. C. Recovery of possession ejectment elements 678. In an action for ejectment, the plaintiff must allege 1. Ownership by the plaintiff of some interest in the real property, adequately described. Ownership may be generally alleged, i.e., plaintiff was owner and in possession of Blackacre. This is a legal conclusion, but it is the best practical form of allegation, and hence is treated as an ultimate fact rather than a conclusion of law. 2. Possession and withholding by the defendant. 3. Damage to the plaintiff. D. Negligence. 1. Elements 679. A complaint asserting negligence must contain allegations of duty, breach of duty, damages, and causation. I. Duty 680. The plaintiff must allege the specific facts from which the defendant's duty arose or from which it is inferred, e.g., that the plaintiff was driving on a public highway, customer in the defendant's store, patient under the defendant's care, etc. Example: an allegation that the defendant owed the plaintiff a duty of care is a conclusion of law, and the complaint would be subject to a general demurrer. But an allegation that the defendant was operating her automobile on Main Street near the intersection of Benton Way, and the plaintiff was standing in a bus loading zone in the middle of that intersection, is a sufficient allegation of ultimate facts. From these facts, it can be inferred that the defendant, as a reasonable person, owed a duty of due care to the plaintiff in the operation of her automobile. Compare: if the duty to be inferred rests upon unusual or special circumstances, they must be specifically alleged in the complaint, e.g., a landlord ordinarily owes a duty to his tenant only with respect to known latent defects, see tort summary, so that the landlord's knowledge and the latency of the defects must be alleged. Roman 2. Negligent action or omission, breach of duty 681. In most code pleading states, the plaintiff can allege the defendant's breach of duty generally, i.e., merely alleging that whatever the defendant did was negligently done, or that the defendant negligently failed to do something. 1. Allegation of negligence 682. An allegation of negligence is admittedly a conclusion of law, but in most instances, it is still the best way to describe how the act was done. Thus, in most jurisdictions, an allegation of negligence is treated as a sufficient allegation of the ultimate fact of breach of duty as a rule of convenience and fairness. Rannard v. Lockheed Aircraft Corp., 26 Cal. 2D 149 1945. 2. Allegation of negligent acts 683. Alternatively, a general allegation of negligence may be replaced or supplemented by allegations of negligent acts, showing that the defendant breached a duty of care, e.g., failed to keep a lookout, failed to maintain control of her car. But note, ordinarily, a general allegation by itself is preferable, because it does not tie the plaintiff down to any particular set of facts he must prove on trial. B. And note res ipsa loquitur. If the plaintiff intends to invoke the presumption of res ipsa loquitur at trial, a presumption that the defendant was negligent based on the harm that occurred to the plaintiff without proof of the defendant's exact conduct. See tort summary. Some authorities hold that he must plead facts showing that he does not know the specific details of the defendant's negligence. In most states, however, res ipsa loquitur is no longer a matter of pleading, but one of proper instructions to the jury, to be given when the evidence of negligence is circumstantial. Newing v. Cheatham, 15 Cal. 3D 351 1975. Roman 3. Damages 684. No cause of action in negligence will lie unless injury has been sustained. For rules on pleading damages, see Infra 701-710. Roman 4. Allegation of causation 685. The courts are fairly liberal with respect to pleading causation and will allow allegations in general terms, e.g., that the plaintiff's injuries were proximately caused by the defendant's wrongful act. However, the courts insist that the causal chain between each step of the transaction be clearly alleged. Causation will not be inferred if there is an apparent gap between the defendant's wrongful act and the injuries to the plaintiff. Example: plaintiff simply alleges that she suffered emotional distress as a result of defendant's conduct. This general statement of causation is insufficient, since plaintiff must allege facts showing the causal chain between defendant's conduct and plaintiff's distress, i.e., the time, manner, and manifestations of the distress. Debo v. Horn, 16 Cal. App. 3D 221 1971. 2. Defenses need not be anticipated 686. Ordinarily, the plaintiff is not required in the complaint to anticipate any defense that the defendant may raise, e.g., assumption of risk, contributory negligence, and allege freedom from fault thereunder. The plaintiff can introduce such facts for the first time at trial if the defendant has raised contributory negligence as a defense in her answer. In short, affirmative defenses in the answer are deemed controverted. Mahoney v. Coralijo, 36 Cal. App. 3D 966 1974. E. Products liability. 1. Elements 687. The essential elements of a cause of action for strict liability against the manufacturer or seller of a defective product are that I. Defendant was in the business of making or selling the product in question. Roman 2. Defendant made or sold the product in question. Roman 3. The product was in defective condition, unreasonably dangerous for its foreseeable use when it left defendant's control and when plaintiff used it. And Roman 4. Use of the product proximately caused injury to plaintiff. Reed v. Safeway Stores, 264 Cal. App. 2D 404 1968. 2. Note. Under modern cases, it is generally not necessary to allege or prove privity of contract between the parties as required in a warranty action. Roman 2. The plaintiff's reliance as a user or consumer on the reputation, skill, or judgment of the seller. Roman 3. Any representation or undertaking on the part of the seller. Or Roman 4. Compliance with the provisions of the Uniform Commercial Code applicable to warranty actions. See Tort Summary. F. Fraud. 1. Action at law 688. If the action for fraud is one at law, the necessary elements are I. Representation. Roman 2. Falsity. Roman 3. Knowledge of falsity scienter. Roman 4. Intent to deceive the plaintiff. V. Justifiable reliance by the plaintiff. And Roman 6. Damages. 2. Suit in equity 689. If the suit is in equity, e.g., to rescind a contract because of a fraudulent misrepresentation, the necessary elements are the same, except that scienter and damages need not be shown. See Remedies Summary. 3. Special Pleading Requirement 690. In any event, the ultimate facts in a fraud action must always be pleaded with particularity. General allegations are not sufficient. See Fed. R. Civ. P. 9b. Cyril & Co. v. Superior Court, 49 Cal. App. 3D 22 1975. I. Pleading securities fraud. For federal securities fraud claims, the Private Securities Litigation Reform Act of 1995 requires that the complaint state with particularity facts giving rise to a strong inference that the defendant acted with the requisite state of mind in cases where scienter is an element of the claim. 15 U.S.C. 78 U4B2. Under this standard, the plaintiff must include factual allegations that make the inference of scienter cogent and compelling, and at least as strong as any other inference that could be drawn from the factual allegations. TheLawBooks, Inc. v. Macker Issues and Rights, Limited, 127s. CT. 2499-27. G. Defamation 691. The elements of a defamation claim are as follows. 1. Publication by the defendant to third persons of specified false matter, which is of or concerning the plaintiff. 2. Defamatory nature of statement. I. If the statement is defamatory per se, e.g., an assertion that the plaintiff committed a felonious crime, alleging the statement is sufficient. Megarry v. Norton, 137 Cal. App. 2D 581 1955. Roman 2. If the statement on its face does not appear to be defamatory, it must be alleged that I. Extrinsic facts make this statement defamatory inducement. And Roman 2. The statement was understood as defaming the plaintiff innuendo. Yorty v. Chandler, 13 Cal. App. 3D 467 1970. 3. Causation, i.e., the publication of the defamatory statement caused harm to the plaintiff's reputation. 4. Special damages, where the matter I is not defamatory on its face, some jurisdictions. Roman 2. Is oral slander rather than written libel and does not fall into one of the slander per se categories. Or Roman 3. Appeared in a newspaper or magazine and no timely demand for retraction had been made, some jurisdictions. Briscoe v. Reader's Digest, 4 Cal. 3D 529 1971. And see Tort Summary. H. Contract Actions, 692. A contract action should allege the following. 1. Terms 693. The making of the contract must be alleged, as well as its terms, by I. Stating the specific terms of the contract. Roman 2. Attaching and incorporating by reference a copy of the contract, if it is in writing. Or Roman 3. Giving a general description of the terms of the agreement. Note: in a few states, the plaintiff must also indicate whether the contract was oral or in writing. Cal. Civ. Proc. Code 430-10G. A. Consideration 694. Whether consideration is required to make a promise enforceable is a matter of substantive law, determined by the particular promise. If consideration is required, merely alleging that there was consideration is neither necessary nor proper. 1. Enforceable Promise 695. If the consideration is specifically alleged or other allegations show the promise is enforceable, e.g., because under seal, such allegations indicate consideration. Hence, a general allegation that there was consideration is a mere conclusion. 2. Written Contract 696. In some states, an allegation that the agreement is in writing will satisfy any requirement of pleading consideration, since a written contract is presumed to have been executed for sufficient consideration. Cal. Civ. Code 1614. 3. Adequacy of Consideration 697. Adequacy of consideration may have to be alleged in suits to enforce contracts in equity, e.g., specific performance, because the equitable remedy is available only if the contract is fully fair and just. 2. Performance by plaintiff 698. If the contract required the plaintiff to perform in whole or part before the defendant was obliged to perform, the plaintiff must allege performance on his part or show facts excusing his performance. Note: in some states, the plaintiff may allege this generally, e.g., plaintiff has performed all conditions on his part. Cal. Civ. Proc. Code 457. 3. Conditions Precedent 699. If some external condition must occur before the defendant's obligation arises, the plaintiff must allege that the condition occurred or allege facts constituting an excuse, e.g., impossibility. Note: the occurrence of conditions precedent can be alleged generally. Fed. R. Civ. P. 9C. Cal. Civ. Proc. Code 457 if excuse is relied on. However, it must be specifically alleged. Grunberg v. Aetna Insurance Co. 9 Cal. 3D 566 1973. Roman 2. Distinguish conditions subsequent. The plaintiff need not concern himself with alleging non-occurrence of a condition subsequent. Occurrence of a condition subsequent is new matter to be raised by the defendant in the answer. See Infra 882. 4. Breach 700. The complaint must allege that the defendant failed to perform her obligation, e.g., defendant failed to construct the structure in a proper and professional manner. Defendant failed to pay the sum agreed to be paid or any part thereof. 5. Damages. See below. I. Damages 701. The requisite allegations concerning damages depend on whether the action is in contract or in tort, and if in tort, what kind of injury is involved. 1. Contract actions. I. Promise to pay money 702. The measure of damages for breach of a promise to pay money is the amount of money unpaid, plus interest. An allegation that no part of the sum has been paid or no part except dollar states the damages due. Roman 2. Promise to do an act or sell a thing 703. The measure of damages in this situation ordinarily is the difference between the agreed price and the price at which the plaintiff could obtain equivalent goods or services with reasonable effort at the time of breach. This difference is recoverable on a general allegation of damage in a specified amount, i.e., it is not necessary to allege specifically the contract price computation. Myers v. Stevens, 233 Cal. App. 2D 104 1965. Roman 3. Consequential or special damages 704. The defendant is not liable for other damages in a contract action, unless she was apprised in advance of facts indicating that they would result if she breached the contract. When such damages are sought, facts must be pleaded to show that the defendant was made aware that such losses could result. Fed. Rule Civ. P. 9G. Shook v. Pearson, 99 Cal. App. 2D 348 1950. 2. Tort. I. Negligence and products liability 705. From the fact of injury, pain and suffering may be inferred, and no special allegations are required for these elements of damage. However, other losses, wages, hospital expenses, etc., must be alleged. Roman 2. Defamation 706. Earlier rules distinguished between damages recoverable for slander oral defamation and libel written defamation. Today, allegations showing a defamatory statement are sufficient in most states to permit recovery of damages for indignation and injury to personal reputation. But loss of income or damages to business or profession must be specifically alleged. Smith v. Los Angeles Bookbinders Union, 133 Cal. App. 2D 486 1955. Roman 3. Other torts 707. At common law, there were complicated distinctions between general and specific damages. In modern procedure, it is proper to describe the nature of the injuries, sustained loss of profits, shock and humiliation, etc., and allege their monetary value. 1. Whether a particular type of loss, e.g., loss of profit, humiliation, is recoverable is a matter of substantive law. 2. Whether a particular type of loss must be pleaded is a matter of fair notice. If the loss in question is not one that obviously would result from the conduct complained of, the facts showing the loss must be pleaded. Continental Nut Co. v. Robert A. Berner Co. 345 F2D 395 7th Sir. 1965. Triadine, Inc. v. Superior Court, 240 Cal. App. 2D 536 1966. Roman 4. Punitive damages 708. Punitive damages are allowed only in some types of intentional torts, those involving fraud or willfully inflicted injury. Even when allowed, a claim for them must be made in either the statement of the cause of action or the prayer for relief, so that the defendant is on notice that they are being sought. V. Prohibition on pleading amount of personal injury or punitive damages 709. In some states, plaintiffs are not allowed to state in their complaints the amount of personal injury or punitive damages that they seek. See, e.g., Cal. Civ. Proc. Code 425.010b rationale. There is too great a likelihood that the amounts sought in these categories may be overly inflated and misleading. 3. Distinguish initial disclosure of computation of damages 710. Ordinarily, the plaintiff need not plead in detail the computation of damages sought. In federal court, however, Initial disclosure rules direct each party seeking to recover damages to provide a computation of each category of damages and make pertinent documents available for copying early in the litigation. Fed. R. Civ. P. 26A1II. C. Infra 1358. J. Pleading the common counts. 1. Definition 711. A common count is a simple pleading form seeking contractual or quasi-contractual relief, e.g., to recover the value of goods or services rendered to another, money due on a loan, a balance owing on an account, etc. See Fed. R. Civ. P. Forms 4-8. Example. Defendant is indebted to plaintiff in the sum of $1 for goods sold and delivered by plaintiff to defendant at defendant's request. Is an example of the common count form. The common counts are conclusions of law, but are sufficient to state a cause of action under code pleading. 2. Limitation 712. Pleading by means of a common count cannot overcome a substantive deficiency in the plaintiff's claim, as where the plaintiff supplied goods to the defendant in circumstances not reasonably implying a duty on the defendant's part to pay for them, e.g., the plaintiff voluntarily sent goods to the defendant through the mail and then demanded payment for them. I'm Consequences 713. 1. If the plaintiff pleads a common count in this situation, the pleading is sufficient. But the substantive sufficiency of the plaintiff's claim may be attacked in a motion for summary judgment. See Chapter Roman 8. Burke v. Alperin, 206 Cal. App. 2D 240 1962. 2. If the plaintiff pleads the common count along with an alternative count that pleads the facts, the alternative count will be looked to in order to determine whether the underlying claim is substantively valid. White Lighting Co. v. Wolfson, 68 Cal. 2D 336 1968. 3. In any event, if the common count leaves the defendant uncertain as to what is being complained of, various discovery devices are available by which she may ascertain the facts underlying the complaint. See Chapter Roman 6. K. Form Complaints 714. In many jurisdictions, complaint forms are published for the types of claims that are commonly made. These complaints are usually presumptively sufficient. For example, the forms appended to the Federal Rules of Civil Procedure are explicitly declared to be sufficient under the rules. Fed. R. Civ. P. 84. 4. Splitting of Claims 715. A pleader cannot split a single claim or cause of action into several different parts and file separate suits on each one. If the plaintiff sues on only part of the cause of action he has against the defendant, he is barred from suing later on the balance. This results from the doctrine of res judicata, i.e., that a judgment on any portion of a single cause of action merges the cause of action into the judgment, so that there is nothing left on which to sue. See Chapter Roman 11, where judgment has not been entered, and two cases are pending. Attacks on the pleadings are possible. A. Obvious splitting 716. If the plaintiff is proceeding in two separate actions, and the splitting appears on the face of either complaint unlikely, some states permit a special demurrer on the ground that there is another action pending between the same parties for the same cause. Cal. Civ. Proc. Code 43010C. B. Splitting not obvious 717. More frequently, the splitting will not appear on the face of either complaint, in which case the objection must be raised by the defendant in her answer again, on the ground that another action is pending between the same parties for the same cause. 5. Joinder of claims. A. No compulsory joinder of claims 718. While res judicata may prompt the plaintiff to bring suit upon her entire claim or cause of action above, there is no requirement that she join in a single action what are separate and independent claims. Even where the claims are factually related, the plaintiff has the option of instituting a separate suit on each separate claim, although, as a practical matter, plaintiffs usually join related claims because of the danger of collateral estoppel. See Infra 2305 et seq. B. Permissive joinder of claims. 1. Early Common Law Rules 719. At common law, the joinder of separate claims was permitted only if all claims were in the same form of action and there was identity of parties to each claim. Example: slander could be joined with nuisance or negligent infliction of bodily injury because both claims had the same form of action, i.e., trespass on the case. Moreover, joinder was permitted regardless of whether there was any factual relationship between these claims. Compare: a claim for slander trespass on the case could not be joined with one for assault and battery trespass, even where both claims arose out of the same event, because the two claims involved different forms of action. 2. Equity Rules 720. In equity suits, it was generally sufficient if the claim arose out of the same transaction or transactions and involved a common question of law or fact, i.e., a requirement of subject matter relationship. 3. Code Pleading Rules 721. Under the original Field Code, a plaintiff was restricted as to the causes of action that could be joined in a single complaint. All causes joined had to be the same type of claim, e.g., all for injury to person, for injury to property, or all contract claims, etc., or at least arise out of the same transaction. All such causes had to affect all parties to the action, and no cause could require a venue different from the others. Criticism: these rules frequently prevented a plaintiff from settling all claims against a defendant in a single action, and drastically narrowed the rules on permissive joinder of parties because all causes joined had to affect all parties. In effect, the rules fostered a multiplicity of suits. Roman 2. Note: to remedy this situation, many states have now adopted rules similar to the more liberal federal rule on joinder below. See Cal. Civ. Proc. Code 42710. 4. Federal Rules 722. The modern viewpoint on joinder of claims is represented by Federal Rule 18A, which abolishes all restrictions on the joinder of claims and provides that a party asserting a claim for relief may join as many claims as she has against an opposing party, regardless of subject matter. Limitation in multi-party cases 723. While there are no restrictions on the number or nature of claims that may be joined where a single plaintiff is suing a single defendant, the rules on joinder of parties impose limitations where there are several co-plaintiffs or co-defendants. When there are multiple parties, at least one of the claims by or against each party must arise out of the same transaction, occurrence, or series of transactions and occurrences, and must involve a common question of law or fact affecting each of the parties joined. Fed. R. Civ. P. 20A. 1. Effect. The joinder of parties rules thus limit the joinder of claims in multi-party cases to those among which there is a subject matter relationship. Example: plaintiff may sue defendant 1 and defendant 2 for personal injuries sustained in a 3-car collision, asserting claims against both defendant 1 and defendant 2 because the same transaction is involved. Plaintiff may also join a separate claim she has against defendant 2 for non-payment of a promissory note, even though this does not affect defendant 1 in any way, because there are common questions of law affecting defendant 1 and defendant 2 in the personal injury claim. Roman 2. Separate Trials 724. In its discretion, the trial court may remedy any possible inconvenience or prejudice caused by the joinder of claims by ordering separate trials. Fed. R. Civ. P. 20b. 42b. 1. Distinguish. If the claims are brought in separate suits, but have related subject matter, the defendant may move to have the trials consolidated. Fed. R. Civ. P. 42a. Below. Roman 3. Distinguish subject matter jurisdiction 725. In federal court, subject matter jurisdiction requirements must also be satisfied. For claims that arise out of the same transaction, there would ordinarily be supplemental jurisdiction, see supra, 455-483, as long as one claim is a federal claim. But otherwise there must be an independent basis for subject matter jurisdiction, such as diversity of citizenship with regard to permissively joined claims. 6. Consolidation of separate actions, 726. The trial judge has the power to order separate lawsuits tried together, or have them consolidated into a single action, if they involve a common question of law or fact. Fed. R. Civ. P. 42A. Cal. Civ. Proc. Code 1048A. A. Actions pending in different courts, 727. If separate actions involving related facts are pending in different courts, many jurisdictions permit one or more of the actions to be transferred, so they can be consolidated or joined for trial in the same court. The cases may be transferred in whole or in part. 1. State Procedure 728. Transfer in state courts may be ordered where it will promote the just and efficient control of the various cases involved, and may involve transfer of the whole action, or only certain issues, e.g., liability. Cal. Civ. Proc. Code 404. 2. Federal Practice 729. Federal, multi-district litigation may be consolidated in one district for all pretrial purposes. Development of issues, discovery, pretrial conference. 28 U.S.C. 1E407. However, the parties have a right to trial in the district where the action was filed, unless the action was transferred to another district where it might have been brought. 28 U.S.C. 1E404A. C. Supra. 186 et sec. D. Challenges to complaint. 1. In general, 730. Before responding to the factual allegations in the plaintiff's complaint by admitting or denying them, or setting forth some defense or offset thereto, a defendant may challenge the legal sufficiency of the complaint. 2. Common Law 731. At common law, defects in the pleadings could be raised by a demurrer. There were two kinds of demurrer. A. General demurrer 732. A general demurrer challenged the substantive sufficiency of the cause or causes in the complaint. It did not specifically state the reason for demurring, but asked the court to pause demurrer and look at the complaint to see if it stated a valid case. Otherwise, why prolong the proceeding? This is still the basic idea of a general demurrer. B. Special demurrer 733. This common law demurrer specially stated a matter to be scrutinized in the complaint, e.g., incapacity of plaintiff, allegations that were too vague, etc. Hence, the special demurrer challenged matters of form. 3. State Practice 734. The Field Code, as adopted in states such as California, preserved the demurrer. In other states, such as New York, a motion to dismiss, or when the objection is that the pleading is vague, a motion to make more definite and certain is used instead. See Infra 779. However, the functions of these challenges are similar. A. Demurrer 735. A demurrer is a pleading filed by one party for the purpose of challenging the legal sufficiency of the other party's pleading. 1. Pleading subject to demurrer 736. The most frequent use of the demurrer is to challenge the plaintiff's complaint. However, the plaintiff may demur to an affirmative defense, counterclaim, or cross-complaint filed by the defendant. 2. Grounds for demurrer 737. The grounds for demurrer usually include the following: Cal. Civ. Proc. Code 43010. I. Lack of jurisdiction over the subject of the action. Note that lack of personal jurisdiction usually must be challenged by a motion to quash, because a demurrer constitutes a general appearance, which would have the effect of waiving the personal jurisdiction challenge. Roman 2. The plaintiff lacks legal capacity to sue. Roman 3. Another action is pending between the same parties for the same cause. Roman 4. Defect or misjoinder of parties. V. Failure to state facts sufficient to constitute a cause of action the general demurrer below. Roman 6. Complaint is uncertain, ambiguous, unintelligible, and Roman 7. In an action upon a contract, inability to ascertain whether the contract is oral or written. 3. General vs. Special demurrer 738. A demurrer for failure to plead facts sufficient to constitute a cause of action is considered a general demurrer. A demurrer on any other ground is a special demurrer. Issue. In ruling on a general demurrer, the court must accept all facts pleaded as though they were true. The issue is whether, assuming that the well-pleaded facts are true, the facts would entitle the plaintiff to some form of judicial relief. Roman 2. Standard. If the complaint alleges facts sufficient to constitute some valid cause of action, the general demurrer will be overruled. The test is whether the complaint sets forth any good cause of action. 4. Defect appearing on face of complaint 739. The demurrer challenges only defects that appear on the face of the pleading or matters of which the court can take judicial notice, well-known facts or facts that can readily and reliably be confirmed by resort to, e.g., an almanac. See evidence summary. A demurrer cannot be used to introduce facts to controvert what is alleged in the pleading, i.e., speaking demurrers are not allowed. Note. For this reason, certain grounds of demurrer, e.g., a plaintiff's lack of legal capacity or non-joinder of parties, are rarely sustained. Such defects rarely appear on the face of the plaintiff's complaint, and thus must be raised by motion see below, or by affirmative defense in the answer. Roman 2. But note, where the plaintiff's own allegations disclose some complete defense, e.g., running of statute of limitations on the face of the complaint, a general demurrer will lie unless the plaintiff has somehow pleaded around the defense. 5. Procedure 740. A demurrer normally must be filed within the time permitted to answer the complaint. See Infra 903. The defendant may choose to demur and answer at the same time, as where the demurrer goes to only one portion of the complaint. 1. Demurrer must specify defect 741. The defendant's demurrer must be in writing and must specify the ground for objection. Unless it does so, it may be disregarded. Cal. Civ. Proc. Code 43060. Example. Plaintiff's complaint fails to state a cause of action in that it does not allege what consideration, if any, was given for defendant's promise, is a sufficient demurrer. 6. Ruling on demurrer effects. 1. Ruling limited to grounds raised 742. Normally, the court has no power to raise grounds for demurrer on its own. Its ruling must be based on the grounds raised by the demurring party. 1. Exception. However, the court may always raise lack of subject matter jurisdiction and the question of whether the pleading alleges facts sufficient to constitute a cause of action. 2. Where demurrer is overruled 743. If the demurrer is overruled, the defendant will be ordered to answer the complaint within a period of time designated by the court. The defendant will then have to make a decision either to I file an answer, or Roman 2 refuse to do so, allow the plaintiff to obtain a default judgment, and appeal the default judgment. 1. If the defendant files an answer, she waives any error in the overruling of a special demurrer. However, the defendant retains the right to object that the complaint does not state a cause of action. 2. If the defendant does not file an answer and appeals the resulting default judgment, she takes a big risk. An appellate court will not reverse unless the judgment was so plainly erroneous as to constitute an abuse of discretion. Hu v. Fang, 104 Cal. App. 4th 61 2002. 3. Where demurrer is sustained. 1. Specify grounds 744. In some states, the court must specify the particular ground or grounds upon which the demurrer is sustained. Cal. Civ. Proc. Code 472D. 2. Leave to amend 745. Having sustained the demurrer, the court normally grants the plaintiff leave to amend the complaint. A. If the court is convinced that the defect cannot be cured by amendment, especially where the plaintiff has already tried unsuccessfully to amend, it may sustain the demurrer without leave to amend. In that event, a judgment of dismissal is entered from which the plaintiff can appeal. B. If the plaintiff is granted leave to amend and amends the complaint within the time permitted, the defendant again has the choice of answering or demurring to the amended complaint. C. If the plaintiff chooses not to amend or fails to amend within the time permitted, a judgment of dismissal will be entered. The plaintiff can then obtain appellate review, but the appellate court will affirm the dismissal if 1. The complaint was defective in substance, even though the trial judge was incorrect as to the ground on which it was defective, e.g., Friendly Village Community Association v. Silva and Hill Construction Co. 31 Cal. App. 3D 220 1973, or 2. The complaint was defective in form, and the party failed to use an opportunity given him in the trial court to clarify his pleading, e.g., Cooper v. Leslie Salt Co. 70 Cal. 2D 627 1969. Note: appellate courts do sometimes give plaintiffs a second chance to amend in this situation. See, e.g., Gillespie v. Goodyear Service Stores, 128 SE2D 487 NC, 1963. Remand to allow plaintiff to replead. 7. Effective failure to raise ground for demurrer 746. Grounds for demurrer are waived unless raised in the defendant's initial pleading demurrer or answer. Where the defect does not appear on the face of the complaint, e.g., a plaintiff's lack of capacity to sue, it will, of course, have to be raised in the answer. Cal. Civ. Proc. Code 43080. 1. Exceptions 747. Failure to state facts sufficient to constitute a cause of action and the court's lack of subject matter jurisdiction are never waived. These objections can be raised at any time. Cal. Civ. Proc. Code 43080. 2. Waiver of objections to personal jurisdiction and process 748. Since a general demurrer constitutes an appearance in the action, it results in a waiver of objections to personal jurisdiction and to sufficiency of process. Note: in some code pleading states, a defendant may be able to preserve objections to personal jurisdiction even though he files a demurrer by simultaneously filing a motion to quash service of process. Cal. Civ. Proc. Code 41810 E1. 8. Criticism of demurrers 749. Modern writers generally condemn the demurrer as encouraging dilatory tactics by the defendant. Although a general demurrer undoubtedly serves a valuable function in weeding out claims without any legal basis, demurrers that merely attack the form of the complaint can be used for the sole purpose of delay, and thus perpetuate technical objections and technical rules of pleading. B. Motion to strike 750. The only other challenge usually permitted against the form or contents of a pleading is a motion to strike, which normally lies to reach defects not subject to demurrer. Filing a motion to strike extends the time within which to answer the complaint. This enables the defendant to obtain a court order striking improper allegations from the complaint before being obliged to answer them. Cal. Civ. Proc. Code 435C. 1. Formal defect 751. The usual grounds for a motion to strike are that the pleading attacked contains irrelevant or redundant matter, e.g., evidentiary matters or conclusions of law, or has some defect in form, which is not a ground for demurrer, e.g., lack of verification or subscription, late filing. 2. Substantive defect 752. A motion to strike can also be used to eliminate part of a claim that is otherwise valid, e.g., punitive damages sought in a suit for breach of contract. Brunius v. Parrish, 132 Cal. App. 4th 838 2005. 4. Federal Practice 753. The federal rules have de-emphasized pleadings C supra 628 and accordingly limit the form and manner in which pleadings can be attacked. A. Motion to dismiss 754. Under the federal rules, the motion to dismiss is the basic challenge to the legal sufficiency of adversary pleadings. Fed. R. Civ. P. 12b. Making such a motion is always optional with the defendant, since he can raise the same objections in his answer below. 1. Permissible grounds 755. The motion to dismiss can be made only on the following grounds with any other defenses or objections raised in the answer. 1. Lack of jurisdiction over the subject matter. 2. Lack of jurisdiction over the person. 3. Improper venue. 4. Insufficiency of process. 5. Insufficiency of service of process. 6. Failure to state a claim upon which relief can be granted. And 7. Failure to join a party whose joinder is required by Rule 19 necessary or indispensable parties. 2. Failure to state a claim 756. When the motion is made under Federal Rule 12b-6 failure to state a claim, its function is basically that of a general demurrer supra 738. Assuming the facts pleaded are true, do they constitute a legal claim upon which the plaintiff is entitled to judicial relief? 1. Test for sufficiency of complaint 757. In testing the sufficiency of the complaint in connection with a Rule 12b-6 motion, the following principles are generally applied. 1. Facts not explicitly required 758. The complaint generally need not contain the ultimate facts. Federal Rule 8a2 requires only a short and plain statement of the claim, showing that the pleader is entitled to relief. 2. Liberal standard for sufficiency 759. The Supreme Court stated in 1957 that the complaint should not be dismissed unless the court is certain that the plaintiff cannot prove a set of facts in support of his claim that would entitle him to relief. Kamai v. Gibson, Supra 630. Example. A complaint charging slanderous utterances by defendant was held sufficient, notwithstanding its failure to state, in so many words, that there had been a publication of the alleged defamations, because that could fairly be inferred from the allegations made. Garcia v. Hilton Hotels, 97F. Sup. 5 DPR, 1951. A. New Standard Plausible 760. However, in 2007 the court declared that the no set of facts directive should be retired, because a complaint in federal court must show affirmatively that the plaintiff's factual allegations make the plaintiff's entitlement to relief plausible. Bell Atlantic Corp. v. Toombly, Supra 630. B. Code Pleading Standard Compared 761. Nevertheless, the federal standard is more lenient than the requirements imposed by many state courts under code pleading. For example, Form 9 of the federal rules states that the following is sufficient to allege negligence. Defendant negligently drove a motor vehicle against plaintiff. This relaxes the requirement in some code states that the plaintiff specify the underlying failure of the defendant upon which the claim of negligence is based. See Supra 681. 3. Continuing need to set out factual matter 762. Despite the absence of a specific requirement for allegations of fact in the rules, the plaintiff's complaint must contain factual matter sufficient to show that the plaintiff is entitled to relief against the defendant. Example. Plaintiffs making an antitrust claim that defendant providers of local telephone services entered into an agreement to exclude other companies from competition, and also agreed not to compete with each other in providing local telephone services, failed to state a claim for relief. Although plaintiffs made a conclusory allegation that defendants had reached such an agreement, their factual allegations did not make their conclusion of conspiracy plausible. Bell Atlantic Corp. v. Toombly, Supra 630. 4. Fraud or mistake 763. When claims are based on fraud or mistake, the federal rules require the plaintiff to plead with particularity. Fed. R. Civ. P. 9b. A. Claims affected 764. This requirement of added specificity applies only to claims where the substantive right to relief depends on proof of fraud or mistake. Examples include common law fraud, securities fraud, and actions to rescind or modify a contract for mutual mistake. Rationale: courts explain that the added specificity is important to provide added notice and that it protects defendants against unfounded claims that damage their reputations. However, it is difficult to understand why the claims covered give rise to especially troubling problems compared with other claims not covered by the rule. B. Application 765. Courts usually look to whether the plaintiff has provided specifics concerning the date and content of representations on which a fraud claim is based. In cases involving multiple defendants, it may be necessary for the plaintiff to specify the involvement of each one that allegedly gives rise to liability, sometimes requiring very great detail. However, some courts say that to satisfy Rule 9b, the plaintiff need provide only slightly more than that which is required by Rule 8a2. See, e.g., Tomra v. Galt, 511 F2D 594 7th Sir. 1975. C. State of Mind 766. Rule 9b also provides that malice, intent, knowledge, and other condition of mind can be averred generally. This exempts all allegations on these subjects from the particularity requirement of the rule. Nevertheless, some courts apply the particularity requirement to allegations relating to state of mind. See, e.g., Ross v. A.H. Robbins Co. 607 F2D 545 2D Sir. Cert. Denied. 446 U.S. 946 1980 in securities fraud action. Plaintiffs required to plead facts giving rise to a strong inference that defendants knew falsity of their statements. D. Requirements of Private Securities Litigation Reform Act 767. Under the Private Securities Litigation Reform Act, PSLRA, most federal securities fraud claims must specify each statement alleged to have been misleading, the reason or reasons why the statement is misleading, and if the defendant is liable only for acting with a certain state of mind, e.g., knowledge or intent. State with particularity facts giving rise to a strong inference that the defendant acted with the required state of mind. 15 U.S.C. 78 U4B. Under this standard, plaintiffs must include factual allegations that make the inference of scienter cogent and compelling, and at least as strong as any other inference that could be drawn from the factual allegations. TheLawBooks, Inc. v. Macker Issues and Rights, Limited, 127 S. CT, 2499-27. 5. Heightened specificity for other types of claims, 768. With regard to certain other types of claims, some federal courts have developed pleading requirements that seem to go beyond the liberality of can lie. A. Civil rights claims 769. The most prominent examples are civil rights claims. In such claims, courts often insist that plaintiffs allege with specificity the basis for their belief that the defendants acted with forbidden animus. See, e.g., Fisher v. Flynn, 598 F2D 663 1st Sir. 1979, requiring employment discrimination plaintiff to plead basis for believing that firing was in retaliation for her rejection of supervisor's sexual overtures. Albany Welfare Rights Organization Day Care Center, Inc. v. Schreck, 463 F2D 622D Sir. 1972, plaintiff required to plead basis for believing that defendant officials refused to deal with plaintiff in retaliation for plaintiff's political activities. B. Other claims analogous to fraud 770. Lower courts have also found that more stringent pleading requirements are appropriate in cases that involve contentions or litigation problems analogous to fraud. See, e.g., Chiron Corp. v. Abbott Laboratories, 156 FRD, 219 ND, Cal. 1994 particularized pleading required for defense of inequitable conduct by plaintiff in obtaining patent in suit. Cash Energy, Inc. v. Weiner, 768F. Sup. 892D. Mass. 1991 more specific pleading required for claims made personally against corporate officers in environmental cleanup suit. C. Qualified Immunity, 771. Another area in which lower courts have required that plaintiffs plead with more specificity are cases in which local officials claim qualified immunity against suit. Elliott v. Perez, 751 F2D 11472 5th Sir. 1985 in cases against government officials involving the likely defense of immunity. Trial judges must demand that the plaintiff's complaint state with factual detail and particularity the basis for the claim, including why the defendant official cannot successfully maintain the defense of immunity. D. Stimulus for heightened pleading requirements, 772. The motivation for this intensification of pleading scrutiny is concern about the settlement value of frivolous or groundless claims. C. E.g., Blue Chip Stamps v. Manor Drug Stores, 421 U.S. 723 1975 Court, stated that the liberal discovery provisions can give complaints with little chance of success on the merits, a disproportionately high settlement value to plaintiff, as long as he can prevent suit from being resolved against him by dismissal. E. Supreme Court disapproval of heightened specificity requirements, 773. The Supreme Court has held that in cases not covered by Rule 9b, the lower courts may not impose heightened specificity requirements. But it has also held that giving adequate notice in a complaint can require specifics. Example: it was improper to require more specifics from a Hungarian plaintiff who asserted that his French employer engaged in age discrimination and discrimination on grounds of national origin, alleging that the employer said he wanted to energize the firm and promoted an inexperienced French employee over the plaintiff, who had wide experience in the industry. The lower court had required that the plaintiff plead the facts required to make a prima facie showing of discrimination. But the Supreme Court held that this evidentiary standard did not have to be satisfied at the pleading stage, noting that Rule 9b does not apply to employment discrimination cases. Swierkiewicz v. Sorma, N.A., 534 U.S. 506-20. Example: it was improper to require plaintiffs suing local law enforcement officers to satisfy heightened specificity requirements regarding qualified immunity, because the claims are not governed by Rule 9b. Leatherman v. Tarrant County Narcotics Intelligence and Coordination Unit, 507 U.S. 163 1993. Compare. Plaintiffs making an antitrust claim that defendant providers of local telephone services entered into an agreement to exclude other companies from competition, and also agreed not to compete with each other in providing local telephone services, failed to state a claim for relief. Although plaintiffs made a conclusory allegation that defendants had reached such an agreement, their factual allegations did not make their conclusion of conspiracy plausible. Bell Atlantic Corp. v. Toombley, Supra, 630. Compare. In a securities fraud action, plaintiffs asserted that the value of the shares they bought was improperly inflated due to defendants' misrepresentations about the company's financial condition and prospects. Although plaintiffs alleged that share values had fallen almost 50% after the company announced that its earnings would be disappointing, the court held that they did not adequately allege loss causation, that the decline in the share price was due to the misrepresentations. The court held that Rule 8A2 required more to give fair notice of what that plaintiff's claim is and the grounds on which it rests. Dura Pharmaceuticals, Inc. v. Broudno, 544 U.S. 336 2005. F. Alternative of requiring reply or entertaining motion for more definite statements, 774. The Supreme Court has stated that in suits involving official immunity, a district court must exercise its discretion so that officials are not subjected to unnecessary and burdensome discovery or trial proceedings. If the plaintiff can overcome a public official's defense of immunity only with proof of a wrongful motive, the court may insist that the plaintiff put forward specific, non-conclusory factual allegations that establish the motive. A court has two primary options for accomplishing this. The court may order a reply to the defendant's or a third party's answer under Federal Rule of Civil Procedure 7a. Or II, the court may grant the defendant's motion for a more definite statement under Rule 12e, Crawford LV. Britain, Supra, 655. One reply required 775. One lower court has ruled that it is an abuse of discretion for a district court to fail to require a plaintiff to file a reply after the defendants have raised qualified immunity, unless the plaintiff's complaint was pleaded with particularity. Reyes v. Sazin, Supra, 655. 2 Rule 8a not applicable to a reply 776. The same lower court has concluded that because Rule 8a, which requires a short and plain statement of the grounds for jurisdiction and of the facts showing a right to relief in a complaint, does not list Rule 7 replies, Rule 8a's short and plain standard does not govern Rule 7 replies. Schulte v. Wood, 47 F3D 1 Forward 27 5th Sir. 1995. 3. Amendment by plaintiff. If motion to dismiss is granted 777. Granting or denying leave to amend rests in the discretion of the court, but leave must be liberally granted. Fallman v. Davis, 371 U.S. 178 1962. 1. If the plaintiff amends, he waives any error in the ruling on the original complaint, unless he can show that the outcome of the action was prejudiced by the erroneous dismissal of the original complaint. 2. If the plaintiff chooses not to amend, or if leave to amend is denied, the court will enter a judgment of dismissal. The ruling on the motion is not an appealable order, but the judgment can be appealed. 1. If the plaintiff appeals and wins, the complaint is reinstated, and the defendant must answer. 2. If the plaintiff loses on appeal or fails to appeal, this generally bars any further proceedings in the action. However, the appellate court has discretion to remand in order to permit an amended complaint to be filed. 4. Answer by defendant. If motion is denied 778. If the defendant's Rule 12b motion is denied, she must answer and proceed with the litigation, i.e., the appellate court will not re-examine the denial of the defendant's motion as such. However, the defendant can raise the same issues on appeal from the final judgment, and by subsequent motions for judgment as a matter of law, for directed verdict, for judgment notwithstanding the verdict, etc., which can also be reviewed on appeal from the final judgment. B. Motion for more definite statement 779. Rule 12e permits a very limited attack on the form of the pleadings, and to this extent serves somewhat the same function as the special demurrer for uncertainty in code pleading practice. However, the motion will be granted only where the pleading under attack is so vague and ambiguous that it would be unreasonable to require the moving party to reply to it. Fed. R. Civ. P. 12e. 1. When available 780. A motion for a more definite statement is appropriate only if the pleading being attacked requires a response. If no response is permitted to the pleading under attack, e.g., a defendant's answer, the motion is never proper. 2. As predicate for Rule 12b-6 Motion 781. Numerous cases have found that the motion for a more definite statement should not be used as a predicate for a Rule 12b-6 motion to dismiss for failure to state a claim. See, e.g., United States v. Board of Harbor Commissioners, 73 FRD, 460D, Dell, 1977, but the Supreme Court has recognized that in some circumstances it is an important way of making plaintiffs put forward specific, non-conclusory factual allegations. Crawford LV. Britain, Supra, 774 thus. Although there may be a bias against using a Rule 12e motion as a precursor to a Rule 12b6 motion, it appears to be proper to do so if there actually is a substantial threshold question that may be dispositive, e.g., whether the facts are sufficient to overcome official immunity. 3. Motion available, even if complaint states claims 782. If a complaint is unduly wordy or otherwise in improper form, a court may require a more definite statement, even though the complaint states a claim. Moreover, if the plaintiff fails to comply, the complaint may be dismissed, even if it is not wholly without merit. McHenry v. Wren, 84 F3D 1 in Wynyard 72 9th Sir. 1996. C. Motion to strike 783. Either party may move to strike an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter in the other's pleadings. Fed. R. Civ. P. 12F. 1. Limited use 784. The motion to strike is said to be disfavored, and generally will be denied unless the allegations attacked have absolutely no possible relation to the controversy, e.g., allegations that a tribunal was a kangaroo court. Skolnick v. Hallett, 350 F2D 861 7th Sir. 1965. If the alleged matter is merely of doubtful relevancy or doubtful legal value, the motion will be denied. Rationale. Pleadings are not read to the jury in federal court, except in unusual circumstances where they have special relevance, e.g., when they contain an admission. Consequently, it serves little purpose to strike allegations in the pleadings. 2. Strike portions of complaint 785. A motion to strike may also be used to attack separate portions of the complaint, which are insufficient as a matter of law, e.g., where a plaintiff seeks punitive damages in a breach of contract action, even though, as a matter of law, such damages are not available on such a claim, or where a defendant asserts an affirmative defense that is not applicable to the plaintiff's claim. D. Procedure on motions under Rule 12 786. A motion under Rule 12 must be in writing, and must specify the ground or grounds upon which it is based. Fed. R. Civ. P. 7b1. 1. Facts 787. If the motion is based on asserted facts, these must be established by accompanying affidavits, declarations, depositions, or other evidence. The opposing party may, of course, submit controverting evidence. Note: on a Rule 12b6 motion, scrutiny is ordinarily limited to the face of the complaint. See Infra 796-798. 2. Time 788. The motion must be served within the time permitted the defendant to serve the answer, normally 20 days after service of a summons and complaint. Infra 900. The filing of the motion operates to extend the time within which the answer is due until the court rules on the motion. E. Effects of failure to include defenses in Motion 789. The defendant is never compelled to file a motion under Rule 12. But if she does, she must include therein all defenses and objections that she could then raise by motion. If she omits an available defense or objection, she may not make a further motion on the omitted ground. Fed. R. Civ. P. 12G. She will, however, be able to raise the ground in her answer, unless it is a ground that is waived by failure to raise in the first responsive pleading or motion. 1. Waiver 790. The following defenses are waived unless raised by motion or in the first responsive pleading. Fed. R. Civ. P. 12H1. 1. Objections to the form of the complaint. 2. Objections to venue, personal jurisdiction, or to sufficiency of process. A. Rationale. A party who invites the court to pass upon a threshold defense should bring forth all such defenses, in order to prevent waste of time by piecemeal presentation of defects. B. Defenses not included in answer. Most other defenses must be raised in the answer to be asserted later in the case. If a defendant fails to raise a given defense in the answer, it is sometimes said that it is waived, but actually it can later be raised if the defendant obtains leave to amend the answer to add the omitted defense. 2. Defenses that need not be raised in Answer 791. The following basic defenses need not be raised in the answer to be raised later by motion Fed. R. Civ. P. 12H2, 3. 2. Lack of subject matter jurisdiction. 2. Failure to join an indispensable party. And 3. Failure to state a claim upon which relief can be granted. 3. Limitation 792. Keep in mind that the waiver pertains only to the defenses that could be raised by a Rule 12 motion. Thus, there is no waiver of substantive defenses, e.g., release, novation, payment, etc., which can be raised in only the answer. 4. Distinguish forfeiture of defense due to delay in asserting 793. Under some circumstances, even where a defendant complies with Rule 12H and includes a preliminary defense in her answer, her failure to assert that defense by motion in a timely fashion may be found to forfeit the defense. See, e.g., Hamilton v. Atlas Turner, Inc., 197 F3D 58 2D Sir. 1999 defendant's failure to move to dismiss for lack of personal jurisdiction for over 4 years, while there was substantial pretrial activity in the case, constituted a forfeiture of its objection to personal jurisdiction. 5. Other procedures 794. While the demurrer state practice and Rule 12 motion federal practice are the procedures most commonly used to attack the sufficiency of a pleading, other procedures are likewise available, the most important of which is the motion for judgment on the pleadings discussed infra 1007-1012. 6. Additional rules of pleading 795. In both state and federal practice, the following additional principles apply. A. Materials considered. 1. Pleading on its face 796. In general, challenges to the sufficiency of the pleadings are limited to the allegations of the pleadings alone, and consideration of evidentiary materials, no matter how persuasive, is not allowed. 1. Distinguish summary judgment 797. Evidentiary materials are the basis for decision on a motion for summary judgment. See Chapter Romans 7. 2. Conversion to summary judgment 798. In federal court, if materials outside the complaint are submitted with a motion to dismiss for failure to state a claim and are not excluded by the court, the motion is to be considered a motion for summary judgment. See Fed. R. Civ. P. 12D. and C. Veasley v. Sager. 5 Cal. 3D 153 1971 motion to strike complaint based on materials outside the complaint treated as motion for summary judgment. 2. Speaking demurrers 799. In some code pleading jurisdictions, there was once a practice of allowing speaking demurrers, which went beyond the face of the complaint and called other materials to the attention of the court. This practice has generally been disapproved. 3. Exhibits 800. When a document is an exhibit to the complaint, it is a part of the pleadings for all purposes. Fed. R. Civ. P. 10C. Therefore, it can be considered in connection with a motion to dismiss. 1. Caution. The fact that the court may consider the exhibit in connection with the motion to dismiss does not mean that all assertions in the exhibit are taken as true for purposes of the motion. For example, in a defamation action based on assertions in a letter, the plaintiff might attach the letter as an exhibit to the complaint without admitting that the assertions in the letter are true. 4. Superseded pleadings 801. Reference to earlier pleadings filed by the same party present several kinds of problems. 1. Inconsistent allegations 802. Because parties may ordinarily make inconsistent allegations within a given pleading, see Supra. 651. The fact that the plaintiff made an inconsistent allegation in a previous complaint does not render the current complaint inadequate. 2. Omission of fatal details 803. Where, however, a party has attempted to cure a defect simply by omitting an allegation, the court may look to the previous complaint to determine the sufficiency of the current complaint. Levy, Hensley, 103 Cal. App. 2D 697 1951, where original complaint showed that claim was barred by limitations. Amendment to delete these allegations was ineffective to avoid dismissal. 5. Matters judicially noticed 804. Finally, a pleading is construed in light of facts that may be judicially noticed. Historical facts, geography, etc. Cal. Civ. Proc. Code 430-30A, Green v. Brown and Williamson Tobacco Corp., 72F, Sup. 2D 882 WD. 10. 1999. Court takes judicial notice on Rule 12b-6 motion that consumers were aware that cigarette smoking posed health risks, rejecting plaintiffs' product liability claims based on the Consumer Expectations Test. Example: in assessing plaintiff's reliance in the complaint on remarks of the CEO of defendant quoted in an article, the district judge was justified in considering the full contents of the article, and not only the portions quoted selectively by plaintiffs. Bell Atlantic Corp. v. Toombley, Supra, 630 materials referred to in complaint, but not attached 805. In some instances, the lower courts have considered materials not attached to the complaint in deciding a Rule 12b-6 motion failure to state a claim upon which relief may be granted. In general, the courts explained that these materials were central to the complaint. United States v. Ritchie, 342 F3D 903, 908 9th Sir. 2003. Even if a document is not attached to a complaint, it may be incorporated by reference into a complaint if the plaintiff refers extensively to the document, or the document forms the basis of the plaintiff's claim. But see Sierra v. Morton, 380 F3D 57 2D Sir. 24. Defendant's submission of hearing transcripts that were neither expressly cited in the complaint nor integral to the claims asserted required conversion to summary judgment. B. Anticipatory defenses 806. A complaint need not anticipate affirmative defenses that the defendant might raise. Example: plaintiff is injured, but executes a release of her claim. Later, plaintiff sues for her injuries on the premise that the release was given by mistake. Plaintiff should not anticipate the defense of release, but should simply allege her claim for injury, await the defense of release, and then avoid it by proof at trial. Compare: if plaintiff does anticipate a defense in her complaint, the complaint must also plead facts to avoid it. For example, if plaintiff in the previous example alleges the release, she must also allege facts showing a mistake that would make the release ineffective. Powell v. Lambton, 30 Cal. App. 2D 43 1938. Hoshman v. Esso Standard Oil Co. 263 F2D 499 5th Sir. 1959. 1. Built-in defenses 807. If a defense is built into the complaint because the plaintiff's allegations provide support for it, the defendant may raise the defense on a motion to dismiss for failure to state a claim, even though in general it is an affirmative defense. The common example is the statute of limitations. When the complaint states when the defendant's alleged actions supposedly occurred, the defendant may move to dismiss on statute of limitations grounds. See Infra 888. 2. Duty to investigate 808. Before filing a complaint, the plaintiff's attorney should investigate defenses. See below. E. Attorney's duty to investigate claims and defenses. 1. Introduction 809. Verification and signature requirements for pleadings have long existed. See Supra. 663-670. Until 1983, the original Rule 11 of the Federal Rules of Civil Procedure used a subjective standard for the obligations of a lawyer signing a pleading. The rule looked to actual bad faith of the lawyer in signing the pleading. In 1983, the rule was amended to fortify its requirements and became a major consideration in assessing the obligations of lawyers filing suits and answers, as well as other papers. In 1993, substantial further revisions were made. A. Rationale. The rationale for enhanced scrutiny of lawyer behavior was to promote self-policing by lawyers and deter groundless and frivolous claims. B. Conflicting interpretations. Under the 1983 version, courts gave the rule conflicting interpretations on a number of key issues. C. Policy concerns. Many courts and law professors expressed concern that the 1983 version of the rule unduly constricted creative advocacy. D. Distinguished state court provisions. A number of state courts retain subjective standards. C. E.g. Cal. Civ. Proc. Code 128.5 authorizing sanctions for bad faith actions or tactics that are frivolous or solely intended to cause unnecessary delay. 2. Certification requirement. A. Signature on paper 810. Rule 11 focuses on the signature on a paper filed in court, although it may also apply to later oral argument, advocating a position in a paper C infra 837. B. Applicable to all filings except Discovery 811. The rule applies to every filing in court, but may be most important with regard to complaints and answers. 1. Discovery 812. With regard to discovery filings, Federal Rule 26G imposes similar certification requirements, and Rule 11 does not apply. 2. Applicable to non-attorneys 813. The rule applies to non-attorneys, e.g., parties appearing pro se and, with regard to certain matters, parties represented by attorneys, as well as to attorneys. 3. Matter certified by signature 814. By signing a paper filed in court, a person certifies the following. A. Reasonable inquiry 815. With regard to the factual and legal grounds for the position taken in the paper, the person signing the paper certifies that she has made an inquiry reasonable under the circumstances to support that position. 1. Attorney pre-filing investigation 816. Ordinarily, it is expected that a lawyer will investigate factual and legal assertions before making them in a filing. This can include factual investigation of allegations and legal research regarding legal assertions. B. Allegations or factual contentions have evidentiary support 817. Rule 11 provides that signing a paper filed in court certifies that factual assertions have evidentiary support. Fed. R. Civ. P. 11b3. 1. Option for party lacking evidentiary support 818. The rule provides that a party may make allegations without evidentiary support if the allegations are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. This option is available, however, only as to allegations specifically so identified. 2. Applicable to denials 819. These certification requirements apply fully to denials of factual contentions. Denials may, however, be based on lack of information or belief, but only if specifically so identified. Fed. R. Civ. P. 11b4. 3. Reliance on client 820. Reliance on the client for the factual assertions may be dangerous, although prospective testimony of a client who has personal knowledge of the circumstances would seem to meet the rule's standard. C. E.g. Finance Investment Co. v. Gebert Ag. 165 F3D 526 7th Sir. 1998 Attorney not justified in accepting client's word that it had a right to pursue the claim asserted. Southern Leasing Partners, Limited. v. McMullen. 801 F2D 783 5th Sir. 1986. Blind reliance on the client is seldom a sufficient inquiry. 1. Possible shift under 1993 Amendment 821. Some courts read the 1993 amendments to Rule 11 as indicating that attorneys need only do an inquiry reasonable under the circumstances, and that so long as the client provides prospective evidentiary support for allegations, the attorney has acted properly. Hadges v. Yonkers Racing Corp., 48 F3D 1E322D Sir. 1995. Under the Rule 11 amendments, it is clear that an attorney is entitled to rely on the objectively reasonable representations of the client. 2. Distinguish sanction on client, where attorney reasonably relies on client. 822. Where the lawyer properly relies on the client can be sanctioned for signing documents filed in court in violation of Rule 11, even if the lawyer committed no violation of the rule. Business Guides, Inc. v. Chromatic Communications Enterprises, 498 U.S. 533 1991. 4. Waivable affirmative defense. 823. It is unclear whether a lawyer violates the rule by filing a complaint where the investigation shows that there is a valid affirmative defense that could be waived. 1. Effect or burden of pleading. 824. If Rule 11 forbids filing a complaint in such circumstances, it in essence has converted the affirmative defense into a part of the plaintiff's pleading burden, because the plaintiff would not be allowed to proceed despite being able to plead all the affirmative elements of his claim. C. Supported by law. 825. The signature also certifies that the claim, defense, or other legal position taken in the paper is warranted by existing law or a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. Fed. R. Civ. P. 11b2. 1. Need to research. 826. The lawyer is expected to do research to determine whether there is a legal basis for claims or defenses that are asserted. 2. Objective standard. 827. The rule is intended to create an objective standard. As explained under the 1983 version, it calls for sanctions where it is patently clear that the claim has absolutely no chance of success under the existing precedents, and where no reasonable argument can be advanced to extend, modify, or reverse the law as it stands. Eastway Construction Corp. v. City of New York, 762 F2D 243 2D Sir. 1985. 1. Conflict among district courts. 828. The Supreme Court has said that when there is a conflict on an issue among district courts, it is not frivolous to rely on the issue, even if the position is contrary to controlling circuit precedent, where the question had not yet been decided by the Supreme Court. McKnight v. General Motors Corp., 511 U.S. 659 1994. 2. Attorney's unfamiliarity with area of law. No excuse. 829. The fact that the attorney is new to the area of law is no excuse for making a claim or defense that is unwarranted by law. Zuck v. Eastern Pennsylvania Psychiatric Institute, 103 F3D 294 3D Sir. 1996. Although this was attorney's first copyright case, that did not excuse his failure to ascertain that the claim was groundless under copyright law. 3. Specifying that existing law unfavorable. 830. The courts disagreed under the 1983 version of the rule on whether lawyers were required to state that they were arguing for an extension of existing law. Compare Golden Eagle Distributing Corp. v. Burroughs Corp. 801 F2D 15531 9th Sir. 1986. No need to explain that argument is for an extension of law. With Thornton v. Wall, 787 F2D 151 7th Sir. 1986. Failure to clarify that argument was not based on existing law can be sanctioned. The 1993 amendment does not require identification, but the advisory committee notes observe that a contention so identified should be viewed with greater tolerance under the rule. 146 FRD at 587. 4. Concern about chilling lawyer creativity. 831. In scrutinizing new arguments, Courts are concerned that they might stifle the enthusiasm or chill the creativity that is the very lifeblood of the law. Eastway Construction Corp. v. City of New York, Supra. 5. Monetary sanction not allowed against represented party 832. A monetary sanction may not be awarded against a represented party for violation of the Rule 11 requirement that claims and defenses be supported by law. Fed. R. Civ. P. 11C5A. D. Improper purpose 833. The signature also certifies that the paper was not filed for an improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation. 1. Collateral purpose 834. Some courts have focused on whether a given litigation action seemed to have a collateral purpose, i.e., some objective other than relief in court, finding this to indicate improper purpose. See, e.g., Shabo Food Service, Inc. v. Canteen Corp. 823 F2D 1E73 7th Sir. 1987 Objectively reasonable pleading may be sanctioned based on bad intent. Appeal of Licht and Semenoff, 796 F2D 564 1st Sir. 1986 Litigation used as method for obtaining information to be used in proxy battle between parties. Whitehead v. Food Max, Inc. 332 F3D 796 5th Sir. 2003 Flamboyant tactics to enforce judgment designed to embarrass defendant and obtain publicity for plaintiff counsel could be sanctioned. 2. Purpose irrelevant if complaint not frivolous 835. Other courts have decided that the improper purpose standard is satisfied as long as the complaint is not frivolous. See, e.g., Sussman v. Bank of Israel, 56 F3D 452D Sir. 1995 suit designed to generate adverse publicity about defendant cannot be sanctioned unless frivolous. National Association of Government Employees, Inc. v. National Federation of Federal Employees, 844 F2D 216 5th Sir. 1988. If an initial complaint passes the test of non-frivolousness, its filing does not constitute harassment for the purposes of Rule 11. 4. Objective Standard 836. The Rule 11 standard with regard to the factual and legal basis for the claim is objective, and the actual state of mind of the lawyer is not important. An empty head, but a pure heart is no defense. Thornton v. Wall, Supra. 5. Duty to reevaluate 837. Although Rule 11 focuses on assertions in written filings with a court, it can be violated by later advocating a position previously taken in such a paper. A. Rationale. Oral statements made to the court about matters arising for the first time in court may be made under circumstances where there is insufficient opportunity to investigate. But litigants' obligations with respect to assertions contained in papers should not be measured solely with regard to what they know at that time, and later advocacy of those positions should be based on all information reasonably available. B. No requirement of formal withdrawal. To comply with Rule 11, a party need not formally withdraw an earlier filing. The prescription applies only to later advocacy of the assertion found to be groundless after the paper was filed. 6. Sanctions. A. Discretionary 838. On finding a violation of the certification requirements, a court may impose sanctions. Fed. R. Civ. P. 11C1. 1. Distinguish former Law 839. The 1983 version of Rule 11 provided that a court shall impose sanctions for a violation. This was read to make sanctions mandatory. B. Nature and measure of sanction 840. The court has substantial latitude in selecting the sanction, which may include directives of a monetary or non-monetary nature. Fed. R. Civ. P. 11C4. 1. Limited to deterrence 841. The sanction is to be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. 2. Ordinarily paid into court 842. If the sanction is to pay money, that money ordinarily is to be paid to the court and not to the opposing party. Thus, Rule 11 sanctions are not a fee-shifting device to make the violator pay the victim's attorney's fees or other legal costs. 1. Costs of motion 843. The court may, however, award the prevailing party the costs incurred in connection with the Rule 11 motion. Fed. R. Civ. P. 11C2. 2. Payment to movement warranted for deterrence 844. If it is warranted for effective deterrence, however, the court may direct a payment to the moving party of some or all of its attorney's fees and other expenses incurred as a direct result of the violation. Fed. R. Civ. P. 11C4. 3. Only non-monetary sanctions against represented party regarding legal basis 845. Monetary sanctions cannot be imposed on a represented party for violation of the requirement that contentions may be warranted by law. Fed. R. Civ. P. 11C5A. 4. Sanctions on law firm 846. Ordinarily, a law firm should be held jointly responsible with its partners, associates, or employees for violations of Rule 11. Fed. R. Civ. P. 11C1. 7. Procedure. A. Separate motion 847. A motion for sanctions must be made separately from any other motions. Accordingly, parties cannot simply append a request for sanctions to other papers they file. Fed. R. Civ. P. 11C2. B. 21-day safe harbor 848. The motion is not to be filed with the court until 21 days after it is served on the opposing party, and then only if the challenged paper is not withdrawn or corrected. This provides a safe harbor for parties to reassess their filings without suffering sanctions for realizing that an earlier paper was not supported. Fed. R. Civ. P. 11C2. 1. Must not be too late to withdraw challenged paper 849. A party may not move for sanctions at a time when it is too late for the opposing party to withdraw the challenged paper. Barber v. Miller, 146 F3D 707 9th Sir. 1998 defendant could not move for Rule 11 sanctions after its motion to dismiss was granted. Ritter v. City of Springfield, 109 F3D 288 6th Sir. 1997 defendant could not satisfy safe harbor requirement by serving motion for sanctions after its summary judgment motion had been granted. C. Sanctions on Courts Initiative 850. The court may, on its own initiative, enter an order directing an attorney or party to show that it has not violated Rule 11, a so-called show cause order. Fed. R. Civ. P. 11C3. But monetary sanctions cannot be imposed under these circumstances unless the court issues the order before voluntary dismissal or settlement of the case. Fed. R. Civ. P. 11C5B. D. Sanctions Order 851. If the court imposes sanctions, it should describe the conduct determined to constitute a violation of the rule and explain the basis for the sanction imposed. Fed. R. Civ. P. 11C6. E. Appellate Review 852. Rule 11 orders should be reviewed under an abuse of discretion standard. Cooter and Gell v. Hartmarks Corp. 496 U.S. 384 1990. 8. Sanctions for multiplying proceedings 853. A federal statute authorizes courts to impose sanctions on a person who multiplies the proceedings in any case unreasonably and vexatiously. 28 U.S.C. 1927. This section looks to delaying tactics or excessive litigation activity. Ordinarily, such sanctions depend on a finding of willful bad faith by the offending person. Zuck v. Eastern Pennsylvania Psychiatric Institute, Supra, 829. 9. Inherent power to sanction 854. Federal courts have inherent power to impose substantial sanctions on a party guilty of bad faith conduct, not involving signing of filings, even when Rule 11 does not apply. Chambers v. Nasco, Inc., 501 U.S. 32 1991 repeated acts of deception of court led to imposition of almost $1 million in sanctions. F. Answer. 1. In General 855. The function of the answer is to put at issue the factual allegations in the complaint. The answer accomplishes this by denying the allegations of the claim and/or by setting forth some affirmative defense, new matter, that avoids the effect of the plaintiff's allegations. 2. Denials 856. To put at issue the allegations of the complaint, the defendant's answer must contain effective denials. Allegations not denied are deemed admitted below. A. Form 1. General denials 857. A single general denial will controvert all of the allegations in the complaint, e.g., defendant denies each and all of the allegations in plaintiff's complaint. In most jurisdictions, this is no longer good practice. 1. Federal Pleading 858. In federal practice, the basic requirement of good faith based upon reasonable inquiry in pleading Fed. R. Civ. P. 11 means that a general denial is rarely proper, because there is usually something in the plaintiff's complaint, e.g., allegations about the plaintiff's personal identity and jurisdictional allegations, which the defendant in good faith should admit. 2. State Pleading 859. In some states, a general denial is not allowed in response to a verified complaint. In such a case, the answer must also be verified and specific denials are required. Cal. Civ. Proc. Code 43130D and C. Supra. 668. 1. Exception 860. Verified general denials to a verified complaint may be allowed where the amount in controversy is small. 2. Specific denials 861. Anything less than a general denial can be considered a specific or qualified denial. Several different types of allegations may be used in this regard. 1. Specific denial by Parts 862. The defendant can go through the complaint, paragraph by paragraph or sentence by sentence, admitting or denying each part as appropriate. Where only part of a paragraph or allegation therein is true, the defendant should admit that which is true and deny the balance. Fed. R. Civ. P. 8b4. Zielinski v. Philadelphia Piers, Inc., 139 F. Sup. 408 ed. Pa. 1956. Example. Answering paragraph 12 of plaintiff's complaint, defendant admits providing medical treatment to plaintiff on or about May 15, 1999, and, except as expressly so admitted, denies each and every allegation of paragraph 12. 2. Negativing plaintiff's allegations 863. A denial may be effected merely by repeating the allegation, but prefacing it with a word of denial. 1. Caution denials in the conjunctive negative pregnant Rule 864. This type of denial, if carelessly employed, may be deemed pregnant with an admission of that which the defendant is attempting to deny. Example. Plaintiff's complaint alleges that defendant struck and kicked plaintiff. Defendant's answer that defendant did not strike and kick plaintiff is pregnant with an admission that he may have struck or kicked plaintiff. A. How to avoid. To avoid the negative pregnant problem, the defendant should make the denial in the disjunctive, e.g., defendant did not strike or kick plaintiff. 2. Denials of times, dates, or places 865. Similarly, if the complaint alleges that an event occurred at a certain time, date, or place not material to the statement of the plaintiff's cause of action, a specific denial thereof may be held pregnant with an admission that the event occurred at some other time, date, or place. Example. Plaintiff's complaint alleges plaintiff fully and completely performed the contract on June 1. Defendant's answer stating that defendant denies that plaintiff fully and completely performed the contract on June 1 may be held to admit performance on another date. A. How to avoid. It is generally a good idea to add, or at any other time, at any other place, etc., to avoid this negative pregnant problem. 3. Ease of avoiding 866. These problems can be easily avoided by denying each and every allegation of the plaintiff, except as expressly admitted, as indicated in 862 supra. As a result, the negative pregnant problem has virtually vanished from the scene under liberalized pleading rules. 3. Denial on lack of information 867. If the defendant is without sufficient knowledge or information to enable her to form a belief as to the truth of allegations in the complaint, she may so state in her answer. Such a statement operates as an effective denial. Fed. R. Civ. P. 8b5. Cal. Civ. Proc. Code 43130. 1. Information that is peculiarly within defendant's control 868. If the information of which the defendant claims ignorance is peculiarly within the defendant's control, use of the denial on information and belief may be forbidden. Example: where defendant bought out the assets of the company that manufactured a product that injured plaintiff, information about the extent to which defendant assumed the tort liabilities of the manufacturer was peculiarly within defendant's control, and defendant could not claim to be ignorant of it. David v. Crompton and Knowles Corp. 58 FRD 444 ED PA 1973. 2. Public Record 869. If matters are of public record, the defendant may not deny for lack of information and belief. Republic of Cape Verde v. A&A Partners 89 FRD 14 SDNY 1980. Compare. In assessing the adequacy of the complaint, the court may refer to matters of which it can take judicial notice. See Supra 804 et sec. B. Effective failure to deny 870. Failure to make an effective denial of allegations to which a responsive pleading is required constitutes an admission of the allegations. Fed. R. Civ. P. 8b6. 1. Exception damages 871. Under federal practice, allegations of damages are deemed at issue, even if not effectively denied. Fed. R. Civ. P. 8b6. State practice is generally contra, i.e., allegations of damages, like any other material allegation, must be denied. 2. Material vs. Immaterial allegations 872. Note that only material allegations are deemed admitted. Material allegations are those essential to the claim and which could not be stricken from the pleading without leaving it insufficient. See Cal. Civ. Proc. Code 43110A. 1. Distinguish. Failure to deny immaterial allegations does not constitute an admission thereof, the immaterial allegations being treated merely as surplusage. 2. But note, in practice, few pleaders feel confident enough to decide what is material and immaterial, and hence deny all allegations. Alternatively, the defendant can move to strike from the complaint whatever she considers to be immaterial allegations before filing her answer. See Supra 750, so she will not have to admit or deny them. 3. Affirmative defenses 873. In addition to or in lieu of a denial, the defendant in her answer must plead any defenses or objections that constitute new matter or an affirmative defense. Such matter is not in issue and hence may not be introduced in evidence at trial under a simple denial. A. Definition 874. Basically, new matter is anything that the defendant must prove in order to avoid the plaintiff's claim, i.e., even assuming the plaintiff's allegations were true, an independent reason why the plaintiff cannot recover. The test usually is whether the defendant would bear the burden of proof on the issue at trial. If so, it is new matter. B. Federal Practice 875. Although burden of proof is generally deemed to be a substantive question for Erie purposes and hence controlled by appropriate state law, pleading rules are clearly procedural. Hence, if an affirmative defense falls within Federal Rule 8C below, it must always be specially pleaded. And this is true whether or not the defendant would have the burden of proof on this issue under state law. Palmer v. Hoffman, 318 U.S. 109 1943. 1. Rule 8C 876. Federal Rule 8C lists various defenses that must be affirmatively alleged, but this list is not all-inclusive. The rule provides that any avoidance or affirmative defense must also be specially pleaded. See Application 877. The following are the most common types of new matter in state and federal practice. 1. Tort Cases 878. In tort cases, 1. Self-defense, consent, justification, or other privilege, as defenses to intentional torts, are new matter and must be specially pleaded in the answer. 2. Contributory negligence and assumption of the risk, as defenses to negligence, are new matter in most jurisdictions. 3. Privilege or license as a defense to trespass. Consent as a defense to conversion are other examples of new matter. 4. But lack of causation is not new matter. Causation is one of the ultimate facts in any tort complaint, and thus lack of proximate cause need not be specially pleaded. It is an issue under a general denial of an allegation that the defendant's acts caused the plaintiff's injuries. 2. Contract Cases 879. In a contract action, new matter that must be specially pleaded, i.e., not an issue under a denial, includes fraud, mistake, duress, incapacity, release, waiver, and estoppel. 1. Illegality 880. Illegality is of course a defense to a contract action, but evidence of the illegality can come in even if not pleaded. 1. Rationale. Public policy to nullify illegal contracts is so strong that it should not require specific pleading. Indeed, the court can raise the issue on its own motion. Santoro v. Carbone, 22 Cal. App. 3D 721 1972. 2. Lack of consideration 881. Wherever the plaintiff has alleged consideration, lack of consideration will be an issue under a simple denial. However, consideration need not always be alleged, see Supra, 694. And where it need not be alleged, lack of consideration is new matter which must be specially pleaded. 3. Failure of conditions. 1. Condition subsequent 882. Occurrence of a condition subsequent that the defendant claims discharged his duty to perform is an affirmative defense, and hence must be specially pleaded as new matter. In re Dibies, 270 BR, 673 Banker. WD, text. 21. 2. Conditions precedent or concurrent 883. However, because the plaintiff must allege the occurrence or performance of all conditions precedent or concurrent in order to show that the defendant was under an absolute, unconditional duty to perform, a denial by the defendant sufficiently controverts the plaintiff's allegations concerning such conditions. See Cal. Civ. Proc. Code 457. A. But note, Federal Rule 9C requires that the defendant's denial pinpoint the particular failure or condition on which she wishes to rely in effect, requiring an affirmative allegation. R. International, Inc. v. Vacances Heliades, SA, 202F. Sup. 2D 788 ND. Ill. 22. 4. Payment 884. If the plaintiff sues on an obligation for payment of money, she bears the burden of pleading and proving non-payment as part of her case. However, if the defendant intends to rely on payment as a defense in the action, most jurisdictions require that she affirmatively plead it in her answer. Fed. R. Civ. P. 8C. Joiner v. Citi Financial Mortgage Co. 800 NE. 2D979 in. 23. Payment is another affirmative defense that must be pled. 5. Mitigation of damages 885. Although the defendant bears the burden of proof as to mitigation of damages, it does not always require special pleading. Example: defendant may prove that plaintiff's damages have been offset or reduced by other income, as where a wrongfully discharged employee obtains another job without special pleading. Such proof goes to the computation of plaintiff's damages and is thus an issue under defendant's denial of the sum complained of. Erler v. 5 Points Motors, 249 Cal. App. 2D 560 1967. Compare. If defendant claims that plaintiff has failed to mitigate damages, e.g., failing to seek comparable employment, this is treated as new matter in order to alert plaintiff. Erler v. 5 Points Motors, Supra. 4. Statute of Frauds 886. The federal rule also followed in most states is that the statute of frauds is new matter and must be specially pleaded. Fed. R. Civ. P. 8C. 1. Minority View 887. Some code pleading states take the position that the statute of frauds is an issue under a simple denial of the contract. This position was originally based on the theory that noncompliance with a statute of frauds rendered a contract void, rather than merely voidable. Although this theory is no longer recognized, see Contract Summary, the pleading rule has remained. Arrow Bolt and Screw Co. v. Gaia, 180 Cal. App. 2D 728 1960. 3. Statute of Limitations 888. Running of the statute of limitations is new matter and must be specially pleaded. 1. But note, if it appears from the dates alleged on the face of the complaint that the plaintiff's action is barred, some courts allow the defendant to raise this defense, e.g., by a motion to dismiss, even though not pleaded in the answer. See Supra, 807. Jones v. Bach, 127s. CT, 910-27. If the allegation, for example, show that relief is barred by the applicable statute of limitations, the complaint is subject to dismissal for failure to state a claim. 2. Title obtained by adverse possession 889. If the running of the statute of limitations establishes title in an adverse possessor, and the former owner then sues for ejectment, the adverse possessor's title is an issue under a simple denial of the owner's allegations in the ejectment action, since one of the necessary allegations is a claim of title. Denham v. Cuddyback, 311 P2D 1E14 or 1957. 4. Pleas in abatement dilatory pleas 890. Pleas in abatement are not defenses on the merits, but assert some reason why the present action should be put off or should not be heard. Matters of abatement often appear on the face of the complaint, and when they do, the complaint is subject to demurrer or similar motion. However, where the matter of abatement does not appear on the face of the complaint, which is the usual case, it must be raised in the answer or, in federal practice, by answer or motion, and it must be specially pleaded as new matter. 1. Grounds 891. The principal pleas in abatement are: 1. The plaintiff lacks capacity to sue. 2. Non-joinder of parties. 3. Another action pending between the parties on the same issues. 4. An action brought prematurely. And 5. Lack of personal jurisdiction, including improper service of process and improper venue. A. In federal practice, these issues may be raised by motion or answer, as long as it is in the defendant's first appearance. Fed. R. Civ. P. 12b. B. In state practice, lack of personal service must be raised by a motion to quash, while improper venue must be raised by motion at or before the time the defendant files a demurrer or answer. Cal. Civ. Proc. Code 41810. 2. Special hearing available 892. Statutes or rules often require that on motion of either party or the court itself, matters of abatement be heard first, since they would dispense with the litigation if proved. See e.g. Fed. R. Civ. P. 12I. 3. Pleas disfavored 893. A plea of abatement is a disfavored defense because it is generally an attempt to put off or hold in abeyance rather than to defend squarely on the merits. Accordingly, the courts require that such matters be raised promptly or the objection will be deemed waived. Thus, for example, such defenses generally cannot be raised for the first time in an amended answer. Collins v. Racha, 7 Cal. 3D 232 1972. D. Effective failure to plead new matter 894. If not pleaded in the answer, new matter is not an issue, and the defendant may not offer evidence of such defenses at the time of trial, unless the plaintiff fails to object to the introduction of such evidence or the court allows leave to amend C. Infra. 977. Mooney v. City of New York, 219 F3D 123 2D Sir. 20. 1. Personal jurisdiction, improper service, and improper venue 895. In federal practice, objections to personal jurisdiction, venue, or manner of service are permanently waived unless asserted at the earliest time, so a later motion to amend cannot revive these waived defenses. Fed. R. Civ. P. 12H1. 4. Procedure in answering complaint. A. Form 896. The requirements for allegations in a complaint supra. 631 at sec. Also apply to the allegations of an answer. B. Signing 897. In federal practice, the same standards apply to the answer as apply to the complaint. Fed. R. Civ. P. 11B4. C. Supra. 665. 809 at sec. 1. Lack of sufficient information 898. Rule 11b4 permits a defendant to deny if the denial is reasonably based on belief or a lack of information. The advisory committee note accompanying the 1993 amendment explained that a denial would be permissible if, after an appropriate investigation, a party has no information concerning the matter or, indeed, has a reasonable basis for doubting the credibility of the only evidence relevant to the matter. A party should not deny an allegation it knows to be true, but it is not required, simply because it lacks contradictory evidence, to admit an allegation that it believes is not true. 2. Verification 899. Under state practice, an answer must be verified if the complaint is verified otherwise. It may be stricken by the court. Cal. Civ. Proc. Code 43130D. C. Time limitations 900. Under federal practice, the defendant must file her answer within 20 days after being served with process, except that if she chooses during that time to file a motion under Rule 12b. This extends the time for filing her answer until 10 days after the Rule 12b motion is denied. Fed. R. Civ. P. 12A1AI. 12A4. 1. Service waived 901. If the defendant waives service of process supra 247, the answer is not due until 60 days after the request for waiver was sent, if addressed to a defendant within the United States, or 90 days if the defendant is outside the country. Fed. R. Civ. P. 12A1I. 2. Service on United States 902. The United States, an agency of the United States, or an officer or employee of the United States sued for actions occurring in connection with the performance of official duties, is allowed 60 days to file an answer. Fed. R. Civ. P. 12A2. 3. State Practice 903. State practice is similar. For example, in California, the defendant must answer or demur within 30 days after service of process, although the 30-day period is measured from different dates, depending on whether defendant was served personally, by mail, or by publication. Cal. Civ. Proc. Code 412-203. 4. Effect of failure to file timely answer 904. See discussion of default procedure infra. 998-1006. 5. Allegations of answer deemed controverted 905. Except where the answer contains a counterclaim below, no reply to an answer is permitted in federal practice unless the court so directs. Fed. R. Civ. P. 7a. Allegations of new matter in the answer are deemed controverted, meaning that the plaintiff has the right, without further pleading, to introduce evidence to defeat or avoid the allegations. Fed. R. Civ. P. 8b6. 998-1006 Cal. Civ. Proc. Code 431-1EB. Example. Plaintiff's complaint charges negligence. Defendant's answer sets up the defense of comparative negligence by plaintiff. This is deemed controverted, and plaintiff can introduce evidence to overcome the comparative negligence defense. See tort summary, even though he has never formally denied defendant's allegations of plaintiff's negligence. A. Reply required 906. The Supreme Court has observed that a reply may be appropriate when a defendant asserts a defense of qualified immunity. Crawford L.V. Britain, Supra, 774. And some courts now require a reply in that situation. See Rays v. Sazin, Supra, 775. 6. Challenges to answer 907. A plaintiff who desires to challenge the legal sufficiency of an affirmative defense may file a demur state practice or a motion to strike any insufficient defense under Federal Rule 12F. A. And note. In addition, the plaintiff may employ a motion for judgment on the pleadings or motion for summary judgment to challenge the new matter. See Infra 1007. G. Counterclaims and cross-claims. 1. Federal practice. A. Counterclaims 908. As part of her answer, the defendant may set forth by way of counterclaim any claims that she has against the plaintiff. Such claims need not be related to the claims set forth in the complaint. Fed. R. Civ. P. 13b. 1. Subject matter jurisdiction. 1. Compulsory counterclaim 909. If the counterclaim is compulsory, i.e., based on the same transaction or occurrence as the plaintiff's claim. See below, it is deemed ancillary to the plaintiff's claim, and therefore within supplemental jurisdiction. See Supra, 455 et seq. 2. Permissive counterclaim 910. However, if the counterclaim is merely permissive below, subject matter jurisdiction requirements must ordinarily be satisfied on some independent ground of federal jurisdiction, e.g., if the plaintiff's claim is based on a federal question, the defendant's counterclaim would have to be based on some federal question or on diversity. It may be, however, that the supplemental jurisdiction statute C Chapter Roman II allows assertion of permissive counterclaims that satisfy the statute's common nucleus of operative fact standard to be part of the same Article Roman III case as the plaintiff's claim, even though not compulsory under Rule 13a. Jones v. Ford Motor Credit Co. 358 F3D 205 2D Sir. 24. In borrower's suit alleging racial discrimination in violation of the Equal Credit Opportunity Act, defendant's permissive counterclaims for the amounts due on loans satisfied the standard for supplemental jurisdiction. 2. Venue 911. Counterclaims have no effect on venue. The venue statutes regulate where the action may be brought, and this refers solely to where the plaintiff files his complaint. 3. Pleading 912. The sufficiency of a counterclaim is tested by the same rules of pleading applicable to a complaint. See Supra, 753 et seq. 1. Form 913. The counterclaim should be set forth as part of the defendant's answer, rather than as a separate pleading. Fed. R. Civ. P. 13a. 2. Caption 914. A counterclaim should always be labeled as such, since a reply to a counterclaim by the plaintiff is mandatory only if it is so denominated. Fed. R. Civ. P. 7A3. However, failure to label a counterclaim as such has no other effect. The court may still treat it as a counterclaim and award whatever relief is appropriate. Fed. R. Civ. P. 8C2. 3. Plaintiff's Reply 915. A responsive pleading by the plaintiff is required to a counterclaim labeled as such. The reply may contain denials, affirmative defenses, or even a counterclaim to the counterclaim. Great Lakes Rubber Corp. v. Herbert Cooper Co. 286 F2D 631 3D Sir. 1960. 1. Note: all matters in the reply are deemed denied or avoided under Federal Rule 8b6. 2. But note: the defendant can attack the reply by a motion for judgment on the pleadings or a motion to strike under Federal Rule 12. 4. Joinder of other parties to counterclaim 916. Although a counterclaim is against the plaintiff, it can be an occasion for the joinder of additional parties. 1. Permissive joinder 917. When making a counterclaim, the defendant may join other persons in accordance with the provisions of Rule 20. Fed. R. Civ. P. 13H. C. Infra. 1973-1083. 1. Caution subject matter jurisdiction 918. Note, however, that when a counterclaim is permissive, there must be some independent basis for federal subject matter jurisdiction. See Supra. Chapter Roman 2. 2. Joinder by order of court 919. If the defendant does not join a party that should be joined under Rule 19 AC Infra 1084-1089, the court may order that party joined on motion of the plaintiff, or, if the party is not joined, proceed to determine whether the case should be dismissed pursuant to Rule 19 BC Infra 1E90 if it is not possible to join the additional party. 1. Subject matter jurisdiction 920. If the defendant has asserted a compulsory counterclaim, ordinarily supplemental jurisdiction would permit the addition of claims against parties who should be joined under Rule 19A. 5. Voluntary dismissal by plaintiff 921. To protect the defendant's right to relief on the counterclaim, Federal Rule 41(2) provides that once a counterclaim is asserted, the plaintiff cannot dismiss the action without the defendant's consent unless the counterclaim remains pending for independent adjudication. See Infra 1E21. 6. Permissive vs. compulsory counterclaims. 1. Permissive counterclaims 922. If the defendant's claims against the plaintiff are unrelated to the claims set forth in the complaint, it is optional or permissive for the defendant to assert them by way of counterclaim, i.e., the defendant may, if she chooses, assert the claims in an independent action. 2. Compulsory counterclaims 923. However, if the defendant's claim against the plaintiff arises out of the same transaction as the claim set forth in the complaint, the counterclaim is compulsory, meaning that it must be asserted in the action, or it will be barred. This bar is implicit in Rule 13A. 1. When counterclaim is compulsory 924. A counterclaim is compulsory if it a. arises out of the transaction or occurrence that is the subject matter of the plaintiff's claim, and b. does not require the presence of third parties over whom the court has no jurisdiction. This provision invokes the requirements of Rule 19C Infra 1084-1089. 2. Scope of transaction or occurrence 925. In determining whether a counterclaim is compulsory, the phrase transaction or occurrence appears to be construed differently, depending on the context. A. Broad view jurisdiction in first action 926. When the question is whether the counterclaim is within the court's supplemental jurisdiction, a broad definition of transaction is used, the object being to permit the counterclaim and thereby to avoid multiplicity of suits. Albright v. Gates, 362 F2D 928 9th Sir. 1966. C. 28 U.S.C. 13367A. B. Narrower view. Scope of preclusion in later action 927. On the other hand, if the question is whether a defendant who failed to interpose a counterclaim is barred from later suing on it, a narrower definition may be used if it would be inequitable to bar the later suit. Bluegrass Hosiery, Inc. v. Spiesman Industry, Inc. 214 F3D 776 Sir. 2000. 7. Statute of Limitations Problem 928. An important issue is whether a counterclaim is barred by the statute of limitations if it is filed after the statute has run, but the action, i.e., the plaintiff's complaint, was filed before the statute ran. The question is considered substantive for Erie Doctrine purposes, and hence is resolved by appropriate state law. Keckley v. Payton, 157 F. Sup. 820 ND. W. 1958. 1. Majority View 929. The general view is that if the counterclaim arises out of the same transaction as the plaintiff's claim, it will not be barred if the plaintiff's complaint was filed before the running of the statute. Rationale. The plaintiff's filing of the complaint places before the court all rights and obligations of the parties to the transaction in question. Berger v. Quimleys, 325 F. Sup. 2D 1E26 ND. Cal. 2004 in addition. In terms of the policies of the statute of limitations, a plaintiff who files suit is clearly on notice of the transaction and has an incentive to preserve evidence about it. 2. Minority View 930. A minority view goes further and allows any counterclaim same transaction or not to be used defensively, i.e., as an offset to the plaintiff's claim, even though the statute has run. Ruppenthal v. Wyoming, 849 P2D 1D 316 YO. 1993. 1. Cross demands deemed compensated 931. Other states reach the same result via statutes that provide that where cross demands for money have existed between the parties at any point in time, they are deemed compensated, i.e., the plaintiff's claim is deemed paid to the extent of the defendant's offsetting claim. If the plaintiff later sues the defendant can set up her cross demand to show payment an affirmative defense, even though an independent action on the defendant's claim would then be barred by the statute of limitations. Cal. Civ. Proc. Code 43170. 2. Limitation 932. Such statutes apply only if the cross demands are for money. Thus, if the plaintiff is suing for recovery of property, the statute of limitations will continue to run on any cross demand which the defendant has against the plaintiff. B. Cross Claims 933. In federal court actions, the defendant may set forth in the answer any claims that she has against a co-defendant that relate to the transaction or occurrence, or to any property that is the subject of the plaintiff's complaint. Such cross claims are never compulsory, however. Fed. R. Civ. P. 13G. Example. Plaintiff sues Defendant 1 and Defendant 2, claiming they were jointly negligent in causing his injuries. Either defendant may cross-claim against the other on any claim arising out of the same accident, but is not required to do so. Scott v. Fancher, 369 F2D 842 5th Sir, 1966. Alternatively, either defendant may file a cross-claim for contribution against the other, asserting that both are jointly liable to the plaintiff and requesting that any judgment be fashioned accordingly. If one defendant is only secondarily liable, he may cross-claim for indemnification against the other who is primarily liable. Lumbermen's Mutual Insurance Co. v. Massachusetts Bonding and Insurance Co. 310 F2D 627 4th Sir. 1962. 1. Jurisdiction 934. Since the cross-claim must relate to the transaction in the existing action, the better view is that it is within the supplemental jurisdiction of the court. and no independent ground for federal jurisdiction is required. Lassa per l'industria del marmo societa per Azione v. Alexander, 414 F2D 143 6th Sir. 1969. 2. Pleading. 1. Form 935. Like a counterclaim, the cross-claim should be set forth as part of the defendant's answer, rather than as an independent pleading. 2. Responsive pleading 936. The co-defendant against whom the claim is asserted must file an answer to cross-claim. Fed. R. Civ. P. 7A4. 3. Parties 937. The basic cross-claim must be against a co-defendant. As with counterclaim, however, the cross-claimant may add new parties against whom it has claims growing out of the same transaction. Fed. R. Civ. P. 13H. 1. Note. A cross-claim is also proper in a case where there are several plaintiffs, Plaintiff 1 and Plaintiff 2, and the defendant has counterclaimed against only one of them, P1. In such a case, Plaintiff 1 could cross-claim against his co-party Plaintiff 2 for contribution or indemnification, as to the claim asserted in the defendant's counterclaim. 4. Other procedures compared. 1. Counterclaims and cross-claims 938. Counterclaims lie only against the opposing party, e.g., the plaintiff, whereas a cross-claim lies against a co-party, e.g., defendant 2. 1. And note. A counterclaim is sometimes compulsory, whereas a cross-claim is always permissive. Priority Records, Inc. v. Bridgeport Music, Inc. 907 F. Sup. 725 SDNY. 1995. 2. Impleaders and cross-claims 939. Impleaders are claims against a third person who is a stranger to the action, whereas a cross-claim lies against a co-party defendant 2. Moreover, an impleader claim is limited to a claim for indemnification or contribution, whereas a cross-claim can be asserted for any claim defendant 1 has against defendant 2 arising out of the transaction that is the basis for the plaintiff's action. 2. State Practice Cross-Complaint 940. Most state rules governing pleading of claims by a defendant against the plaintiff or third parties follow the federal rules above. However, some states, e.g., California, do not recognize the counterclaim or cross-claim, but provide that a defendant's claims against any party plaintiff, co-defendant, or a third person, not yet a party to the action, may be asserted in a cross-complaint. A. Form 941. The cross-complaint is a separate pleading, i.e., not a part of the answer. Cal. Civ. Proc. Code 42840. 1. Procedure 942. If the cross-complaint is filed at the same time as the answer, it may be filed as a matter of right. Otherwise, leave of court must first be obtained for a cross-complaint against current parties to the case. Cross-complaints against new parties can be filed without leave of court until a trial date has been set. Cal. Civ. Proc. Code 42850. 2. Service 943. The cross-complaint must be served on every party to the action. Cal. Civ. Proc. Code 42860. B. Joinder of parties 944. As noted above, a cross-complaint may be filed against the plaintiff, a co-defendant, or a third person, not yet a party to the action. In the latter case, a separate summons is issued on the cross-complaint. 1. Note. The usual rules with respect to necessary and indispensable parties, see infra 1084 et sec. Apply here as well. C. Joinder of claims. 1. Against plaintiff, unlimited scope 945. The defendant may assert any and all claims she has against the plaintiff. There is no requirement of any subject matter relationship to the plaintiff's complaint. Cal. Civ. Proc. Code 42810A. 1. Compulsory cross complaints 946. However, if the defendant's cause of action is related to the subject of the plaintiff's complaint, failure to assert it constitutes a waiver thereof. Cal. Civ. Proc. Code 42630. Basically, the same rules apply as for federal compulsory counterclaims. See Supra 923. 2. Against other parties subject matter relationship 947. A defendant can assert a cross-complaint against a co-defendant or third party only if the cause of action sued upon is related to the plaintiff's complaint, i.e., arises out of same transaction or series of transactions, or involves the same property or controversy. Cal. Civ. Proc. Code 42810b. 1. Effect. As long as there is one such cause of action, the defendant can join with it any other causes of action she has against any of the cross-defendants. Cal. Civ. Proc. Code 42830. A defendant may join additional cross-defendants, although they were not formally parties. Cal. Civ. Proc. Code 42820. Example. Poppy, while operating a car, collides with Tripp, who is operating a car owned by Oliver. Poppy sues Oliver for personal injuries. Oliver may file a cross-complaint against Poppy for the damages to Oliver's car, and against Tripp as a third-party defendant, seeking indemnity for any liability that Oliver may be subjected to in favor of Poppy, and also for the damages to Oliver's car. 2. Note. The California cross-complaint can thus be used to assert the claims asserted under the federal rules by compulsory counterclaim same transaction, permissive counterclaim different transaction, cross-claim against co-party, or impleader bringing stranger in as third-party defendant. D. Responsive pleading required 948. Each cross-defendant must file an answer or demurrer to the cross-complaint. Cal. Civ. Proc. Code 43210. If no such response is filed, a default judgment may be entered on the cross-complaint. 1. Grounds for demurrer 949. The grounds for demurrer to a cross-complaint are the same as for a demurrer to the original complaint. 2. Additional cross-complaints 950. A cross-defendant, in turn, is permitted to file a cross-complaint against any other party or against any stranger to the action, just as if the cross-complaint filed against him had been the original complaint. Cal. Civ. Proc. Code 42810. Note. This means that the cross-defendant is subject to the compulsory cross-complaint provisions above. 3. Note indemnification 951. A special statute in California allows broader defenses where the cross-complaint is for indemnification, e.g., plaintiff sues defendant. Defendant cross-complains against third party, alleging that third party is liable to indemnify defendant against plaintiff's claim, so that if plaintiff wins against defendant, third party is liable to defendant. In such cases, the cross-defendant third party is permitted to assert any defenses to the underlying cause of action plaintiff vs. defendant that could be asserted by the person seeking indemnification from him defendant. Cal. Civ. Proc. Code 42870b. 1. Rationale. The purpose of this rule is to protect against collusion on the underlying cause of action, i.e., defendant admitting or defaulting to plaintiff's claim, in order to saddle third party with the liability. H. Amended and supplemental pleadings. 1. In general 952. Since it is the basic function of pleadings to define the issues in controversy and thus limit the proof at trial, the rules allowing amendments and supplements to pleadings are of vital importance. The problem is the extent to which a party, by amending or supplementing pleadings, can alter or expand his case from that originally set forth in the complaint or answer. As will be seen, this depends to a significant degree on the stage of the proceedings at which an amendment is sought. 2. Amendments prior to trial. A. Amendments as a matter of right 953. Either party may amend his pleading once as a matter of right. Either I before a responsive pleading as opposed to a mere motion is served by the other party, or Roman 2. If the pleading is one to which no responsive pleading is permitted, e.g., the defendant's answer, and the action has not been placed on the trial calendar. at any time within 20 days after the pleading is served. Fed. R. Civ. P. 15A1. 1. Note: even though there is a right to amend, the alteration must be within the permissible scope of amendment C infra 958 et sec, or it is subject to being stricken. B. Amendment by permission of Court 954. In any other situation, a party may amend his pleading only by leave of court. However, such permission is usually granted liberally prior to trial. 1. Rationale. Modern courts stress that the primary function of the pleadings is to give notice of the pleader's claim or defense. As long as the original pleading gave such notice, the claim may be expanded or changed in the course of litigation.